Just a bit. Wait. There is an announcement, not a pronouncement. The learned members of the bar and other stakeholders, I would like to inform that we are commencing the one case, one data initiative to strengthen this court's case management system through a multi-level integration with the database of high courts, district courts, and government. First time it's happening, then the entire data will be now integrated. And while sitting in Supreme Court, we'll have all complete details up to the district court and taluka courts. And similarly, taluka courts will also have all the connectivity here. This new module will automate data retrieval from the concerned court's database and facilitate swift online verification of case-related information. Reciprocal access of case information shall also be provided to high courts and government departments as and when required. This would ensure data integrity and transparency. We look forward to building a collaborative, transparent, and efficient for the Indian judiciary with the support of the learned members of the bar and, of course, high courts for this initiative. We are also launching Su Sahayak, an assisting chatbot for our website developed by NIC in collaboration with the registry. This will provide a simple and convenient interface for citizens through swift, prompt-based guideline and guidance in accessing essential e-services of this court. My best wishes to the registry and to the officers who have done this commendable job. I am quite confident that these initiatives will provide and they will prove to be beneficial for all the stakeholders. Thank you.
That's a great message.
My lord, in this case, we have received the data and responses from all the states. My lord, I have made the compilation in tabular form. My lord, this is ये 2 सेकंड.
How many high courts have filed the compliance affidavits?
I appear for Tripura High Court. We have filed our affidavit. On the last occasion, we could not, but we filed it now.
Kerala High Court also filed. Yeah? No, Kerala High Court has filed.
Madhya Pradesh also has filed.
This is, my lord, tabular form, where I have mentioned that since when the bail applications, petitions, suspension of sentences are pending, and there are in certain courts for more than 10 years, my lord. My lord, I have...
Madras High Court, I personally don't agree anything. Madras High Court is the fastest High Court in terms of disposal of criminal matters.
Yes, my lord.
They are dealing with 2018 murder division bench criminal appeals.
My lord.
It is a dream for all other high courts.
In Kerala also, my lord. In Kerala also, there are 2025 only. But otherwise, there are some high courts, my lord. I have also supplied the suggestions, my lord, that how... My lord, to assist in Patna High Court since 2014 at serial number 3, my lord.
Most problematic high courts are only two, Allahabad High Court and Patna High Court. Who is representing both? Problematic in the sense, but Allahabad High Court, we understand the difficulty. Despite the strength of the judges, despite the best efforts made by the Chief Justice of the High Court and the judges who are hearing 200 plus cases in a day, we really admire their working capacity, but then still it is unmanageable because of the volume. So maybe some new dynamics will have to be adopted there. Who is representing Patna High Court? Right on.
Even with regard to Uttar Pradesh High Court, there is no data showing that since when it is pending, my lord, as far as my scrutiny is concerned, my lord. My lord, I request that there is, earlier also the writ petitions has been entertained by this Honorable Court Shumoto for the purpose of efficient dealing with the criminal justice system, my lord, including trials as well as bails. I have lower court experience, my lord. There are certain suggestions which I have given in trial also. My lord, there is one theory propounded by my lord, theory of invisible victim, my lord. My lord, as far as bail is concerned, my lord, it is for accused to get it decided expeditiously. But as far as trial is concerned, it is for the victim, my lord. And it is not only the complainant. There are so many victims we have experienced, my lord, in so many appeals that there are wives, there are certain children, parents, and other persons who are victim in case of criminal trials, my lord. My submission is that I can assist this honorable court by making certain suggestions how to improve in criminal justice system trial. So,
The scope of this shall you granted. The instant matter originally were directed against an order dated 22nd December 2025, passed by were directed against an innocuous order dated 22nd December 2025, passed by the Punjab and Haryana High Court, dismissing an application in which prayer for preponement of the main case, namely a regular bail petition pending before the High Court, was declined. That bail application has been moved by the petitioner in FIR number 174/2025, FIR number 173/2025, registered at Police Station Sector 17, Faridabad. The grievance was that the petition was in custody since 11th August 2025 and his bail application was being adjourned in the High Court. And no effective hearing were taking place in his bail application, which was where he made a prayer for preponement, but such prayer was declined. Next paragraph. Taking cognizance of pendency of bail applications before various high courts, from the scope wide order dated 4th February 2026, took cognizance of the fact that numerous bail applications were pending, not only before the High Court, from where the instant proceedings originated, but also in different High Courts. This court thus made the following observations, followed by certain directions. Para 3, 4, 5, 6, 7, 8, 9. Next paragraph. In reference thereto, most of the high courts have furnished the requisite information which the senior counsel for the petitioner has tabulated for our ready reference. Though the information is readily available, but we are consciously not incorporating in the order as it, to avoid any, but we do not deem it necessary to incorporate the same in the order, especially for the reason that most of the high courts have taken necessary initiatives for timely disposal of the bail applications. Some of the high courts like Allahabad High Court, where the volume of evidence is too large, and despite the fact that most of the honorable judges are dealing with hundreds of cases in a day, the problem still appears to be problematic. Though it is for Honorable Chief Justice of the High Court, being master of the roster, to evolve an effective mechanism, but maybe the measures like equitable distribution of all bail applications amongst all the judges, including those sitting in division benches, might be one of the solutions. This is, however, only a suggestion from our side, since we are not aware about the internal functioning of the High Court. We leave it to the entire discussion of the Honorable Chief Justice. Internal functioning of the High Court and the rule position. We leave it to the Honorable Chief Justice of the High Court and the Administrative Committee to resolve some mechanism which should ensure that there is a definite date of hearing in all the bail applications, and by judicial resource aggregation, and in the pause list also, the listing of bail applications is prioritized. A similar kind of mechanism ought to be evolved by the Patna High Court, where unfortunately some of the bail applications are urgent for months and months. We are hastening to add that
2004.
the litigants, the pendency of over 60,000, pendency of 60,365 bail applications in the Madhya Pradesh High Court about a year back is also an alarming situation. Though we are hopeful that meanwhile a substantial part of such petitions might have been disposed of. That's right. In any case, this order shall not be taken as an aspersion on the functioning of any high court. It seems to us that some of the suggestions which have been put forth before us we propose to enlist some of the suggestions which have been put forth before us. We propose to the following suggestions put forth before us. One, listing of the bail matters on weekly or fortnightly basis. There can be an automated system also. There can be an automated software-based system where all bail applications can be listed at least once after 2 weeks. 2, mandatory filing of status report before first hearing. It can be made compulsory for the counsel for the petitions to serve a copy of the bail application in advance in the office of the Advocate General or any designated agency of the Union State, and proof of such service should be made mandatory for filing the bail application. The High Courts can, depending upon the total pendency and the resources in hand, evolve a mechanism of listing the bail applications on an alternate, fresh bail applications on alternative day, or at least within a week, with a mandatory condition that the state, a union stroke state shall be represented to whom the advance copy has already been given. Necessarily means that the practice of issuing notice or admission of bail applications shall have to be dispensed with. 3. Automatic relisting of bail applications which are not taken up. It goes without saying if the bail applications are not taken up, could not be taken up due to heavy pendency and or for any other unforeseen reason, the software should ensure listing of such bail applications within the week or on prioritized basis before the fresh filed bail applications are listed. Next paragraph. The High Courts can also resolve to fix an outer timeline for disposal of the bail applications. Next paragraph. The High Courts will also need to evolve a practice of discouraging these union stroke state councils from seeking avoidable or casual adjournments, reminding them the issue of the reminding them the court's solemn duty to protect the most precious fundamental right guaranteed in Article 21 of the Constitution. Main paragraph. This court has also often noticed that in the cases like NDPS matters, the bail applications are not being heard on account of non-availability of the FSL reports. Though we understand that pursuant to the direction issued by this court on judicial side, most of the states have by now established forensic laboratories to ensure timely submission of the reports. However, a lot of improvement is still required to be done. Honorable Chief Justice of the High Courts are accordingly requested to take up the matter with the state governments and other agencies to ensure that FSL reports are delivered within a reasonable time. Next paragraph. The responsibility of investigating officers, especially in victim-centric cases, is also extremely important. They ought to understand, they ought to realize the offenses like under the POCSO Act, SC/ST Act. Don't mention any act. They ought to realize that in some of the matters, any laxity on their part may lead to grant of bail to the accused or suspect on realize that the victim's rights are duly protected. They must ensure while submitting the investigation report that the victim's that the victim and their associates have been duly associated and they have been heard. They have been
The
informed
right of the institution and their right to particular
informed of the report being filed and their right to participate in the court proceedings.
court proceedings and their right to take legal assistance to the consent.
In the court proceedings and avail their right to engage their own counsel.
On counsel or counsel to legal service.
To engage their own counsel or a legal aid counsel.
Victim should be informed, my lord, so that they will be able to engage counsel even to represent in bail applications. Because,
That is what we are saying.
sorry,
It goes without saying that a victim has a right to participate at every stage of the proceedings, including at the time of hearing of the bail application of the accused. Next paragraph. The use of digital police portal for uploading the status reports can also be an effective mechanism as it will facilitate the suspects as well as the victims to find out the status of the ongoing proceedings. Next paragraph. We hope and trust that the high courts, state governments and investigating agencies will take necessary steps to through a collaborative approach and ensure that there exists a robust mechanism for ensuring the timely disposal of the bail applications, and that will also bail applications without affecting the victim's rights. Rather, will be heard on time, simultaneously ensuring that the victim's rights are duly protected.
yes.
So with these directions and observations, these proceedings are disposed of.
May I just suggest one more thing, my lords, for my lords' kind consideration. My lords, there can be some mechanism insofar as status reports are concerned, because that also takes a lot of time for the
We have
bail.
already passed that.
My lords, if I may say, my lords, that like FSL, when was it applied? How much time it has taken?
That direction. With the institution, a copy of the bail application would be served upon the public prosecutor or the standing
Very
prosecutor.
well. Very well.
On the first day, the status report will be filed, which will include the fact that the victim has been notified and her right to participate through her own counsel or legal aid.
Very well.
Milords, one small Milords, I had the benefit of this chart just now, Milords. The number that is indicated against Madhya Pradesh High Court of 60,000, that's Milords the total number of cases filed till date. That is what was indicated in our compliance affidavit. I think due to some Milords labs, there is a column.
Any idea of how much are pending now?
Milords, we have filed that, but I'll have to collate the exact number, Milords. But it is 60,000 is the number of cases totally filed, Milords.
Totally fine.
That's right. It
It
would be less than 2,000.
That's why we have said we are not passing any order. We are only just some suggestions we are giving, only sensitizing the institution, that's all.
I'm aware, but that line would come. Milords.
Yeah, we have a whole line, we will take it, soft report. Item 14.
Please.
So we go up.
Serial number 14, sorry. Serial number 14, my lord.
Hmm?
We have serial number 14.
Take the mic.
Item number 14, my lord. We have been served the copy of the counter by state on Saturday only, requesting for 1 week's time to file reply.
In bail application, you will file, first of all, the practice of filing counter affidavit. We do not know how it has originated. Then you now file starts rejoinder.
We would not file counters in all matters, however, my lords, in this matter, it
He
would.
there from last 1 year, 10 months.
I
ma'am. I'm
understand,
just-
my lords, if I may just say, my lords,
And what is the fault of the poor fellow?
my lords,
He
he
has
is
done
not,
something.
my lords may not say that, my lords, I will be able to show, in fact, what he has
Hire
done, my
him,
lords.
he appears to be a great scientist. Hire his services.
My lord, this was not, he has a motive to kill the man. One 12-year-old girl died in this, my lords, along with the father. Two more injured. The entire ceiling of the house got shattered.
Well,
We have started with the examination of prosecution witnesses, my
how
lords.
many witnesses?
68, my lords. We
not-
will, may I just submit, my lords? 68 witnesses, my lords. We may not examine all, but I must point out, my lords, the two auto drivers, we have recorded the statement on 164. They have,
He's not a hardened criminal, madam.
my lords, it's,
Look at the background. He had suspected that this victim had affair with his wife. So he evolved some method and unfortunately committed this crime.
if I may respectfully submit, my lords, this is not just an unfortunate incident. He was well aware, my lords, of the consequences of the act. He-
Obviously, that's why he committed
And
the
he want-
crime in jail.
In that course of action, my lords, one 12-year-old has also died, my lords. The intention was to kill. That's what I'm submitting, my lords. It has all the ingredients of 302. There is a strong motive.
Exactly.
And
That's why 302 and 307 are there.
is attracted, my lords, clearly, and therefore I'm submitting, my lords, he may not be a hardened criminal, but look at the way he has committed the offense. He has gone to the extent of procuring explosive, assembling it, and then sent it
The
to.
petitioner is an accused in affair.
Would my lords consider only one request, my lords?
That's 1/11209054240204/2024, registered at police station of Wadali, Sabarkantha, under section 302, 307, 120 capital B of IPC, section 9 capital B in bracket 1B of Explosives Act 1884, and section 3 capital A 4B of the Explosive Substances Act 1908. सारे कंट्री का तो लॉ लगा दिया आपने इसके ऊपर.
My lords, all, in fact, I'll be able to show, my lords, all sections are attracted, my lords, in this, and there is overwhelming evidence against him, my lords.
The petitioner has the conspiracy to kill the victim, in bracket Jitendra Bhai, Hira Bhai Banjara, bracket close, who was allegedly having an affair with the petitioner's wife. The petitioner is said to have planted a bomb in the electronic speaker of the auto rickshaw in which the victim was traveling, and when he was the auto rickshaw driver,
No, my lords, no.
was traveling,
He
Well,
gave it to the auto
Jitendra
rickshaw.
Bhai plugged the speaker into the electric board, the bomb exploded, leading to instant death of the victim and his daughter. The daughter of the victim, who was also traveling with him, suffered serious injuries. As per the petition, was arrested on 3rd May 2024. The investigation is complete. Charge sheet was filed on 29th July 2024. The trial has also commenced, in which how many witnesses have been?
68, my lords.
witnesses.
One we have examined. I was only requesting, my lords, may at least permit us to examine the auto drivers, my lords. They are the one who will,
He not a
my lords, he may not.
in his name the auto rickshaw.
Only making this request, I am only making this request, my lords, because these auto drivers is what connects him with the crime, my lords, because he had handed over the
How
pass.
many witnesses have been examined so far?
One, the doctor we have examined, my lords.
Only one witness has been examined so far. The prosecution has listed 68 witnesses. So even if some of them are prone, it is obvious that the conclusion of trial will take long time. So having regard to the fact that the petitioner does not have any criminal antecedents and he is already in custody for almost 2 years, and No, more than 2 years now, more than 2 years. And the conclusion of trial will take some time. However, without expressing any opinion on merits, the instant petition is allowed. The petition is directed to be released in bail, subject to experiencing bail bonds, and subject to the terms and conditions as may be imposed by the trial.
Immensely great.
Please, my lords.
Great.
Item 15.
Item 15, I don't know whether your lordships have got the additional affidavit which was filed. Was filed on Saturday. My lord, pursuant to your lordship's order, so many things had to be gone through. Ultimately, my lord, 6th of May, the bypass surgery was performed. The certificate issued by Jaslok Hospital, my lord, is with my learned friend also. My lord, there were some problems because Hingoli, two places in Maharashtra, they have to go. Ahmedabad, because cases are registered in Gujarat also. Ultimately 6th. And my lord, he was in IT.
Bypass, it will take time.
Yes,
Your lordship may grant me
I
6
have
or 8
verified-
weeks.
I have verified the documents which they have filed, and he has underwent bypass on 6th only, 6th, 7th.
The petitioner is
Your lordship may grant me 8 weeks so that, my lord,
bypass surgery on 6th May 2026. Post this matter after 4 weeks and so on so day.
please, my lord.
July में करो please. But don't say after 4 weeks. Post
Lord, your lordship may say the bail to continue.
Interim bail to continue.
I'm
Lord.
told.
End of the
Well, it's in item 16, your lordships in a connected judgment, your lordship have passed this judgment Sucheta. Well, may I just pass it over? Squarely applies
Cheta ka up judgment.
because I approached with a delay.
So,
No, it's a fresh matter, my lords.
issue notice. Honorable solicitor notice the condemnation of delay also.
My lords may permit to serve the standing counsel so that returnable.
Mr. Trustee notice also. Sunny cancel on it.
Great.
Notice the condemnation delay भी किया है 300.
You don't ask for a representation, dismiss it.
वो भी एक लाइन लिख दो उसमें डिले तो condemn करना है कवर्ड उसकी फेवर में.
Whereas, before your lordship opens the file, because of a rule in the registry, you could not circulate, the representation is on the cusp of being decided. I told lordship last time, the representation is there, it is on the cusp of being decided. If lordship defers it, I'm sure we'll get some way decision one way or the other. Well, I told you lordship last time, our representation is on the cusp of being decided. 7th November 25 is on the cusp of being decided because they've done it for 20 other cases. Allow me that chance, fellows, that's all. According to us, you've done it for other cases. Call it any time after the representative decided, which is, fellows, government takes some time. So June is a holiday, so I can ask for July, fellows. State against you.
Don't dispose of, otherwise we are dismissing it in the.
Well, it's
You can pursue your representation.
thereafter coming will be a
Absolutely
problem.
frivolous claim.
No, it will be difficult coming here. Lordship will say nothing. Lordship will give me one more chance. This oxygen will survive. I will lose ultimately. Your lordship is sizen.
But simply what happened, we don't want to observe in open court. What will happen? Some bureaucrat, some politician will have make this excuse on file. Matter is pending in Supreme
So
Court.
therefore, may I do one thing?
Therefore,
Wait,
it
wait,
should
I understand my lordship. May I do one thing? Lordship will record. Next time, no adjournment will be sought. If it's not given, my bad luck. Let me have this chance. I am instructed by that it is likely to be. Call it once with the noting of your lordships. In July, it will not be adjourned again. I also agree with that. I'm not going to ask your lordship again for this. It will be very sad, but if something is being done there and lordship dismisses it here today, that's the only request in July. Call it any date in July. And please add that sentence with prejudice.
Then say further adjournment is what will be matter. In the interest of justice and as a last.
You understand?
Post the matter on
The merits you want to argue again.
Well,
Well, we will not seek any adjournment next time either way.
May I please, my lord? Your lordship said on 10th of October, my lord, the matter should be decided expeditiously, my lord. It's been, my lord, now
What
3.5.
kind of application direct the High Court? As if the High Court is a subordinate court.
My lord, your lordship has already observed, my lord, in the last.
Whatever observed, we have nothing
My
to
lord,
do.
kindly see para 5, my lord. Your
Yes.
lordship has requested the High Court to decide as expeditious as
therefore,
possible.
No case to entertain this amendment of dismissed.
Deeply obliged.
Well, please file an application before the High Court. Take advantage of para 5. File an application before High Court.
File 3 application, my lord. Nothing is happening, my lord, despite, my lord, 3 applications. In fact, my lord, the Honorable High Court has observed in the order.
Try your luck, sir.
Supreme Court has passed an order, decide the matter expeditiously, my lord. Nothing is happening, my lord. Despite.
Try your luck once again.
My lord may observe in the order, my lord, I will file.
Not done, madam. Land Council
If the Lord-
seeks to permit to withdraw this application as he wants to move a fresh application before the High Court. ये रास्ता निकाल दिया आप चली जाइए.
Lord, deep.
Yes, 19.
My client is not in my touch, my lord. Today morning also I have called his 3 mobile numbers, my lord, but all are switched off, my lord. Notice may be issued to him, my lord. Notice may be issued to him, my lord.
Not deposited first.
Notice may be sent to his address, my lord.
Which family court the matter is pending?
Before the Karkarduma court, my lord.
Say the petitioner has not deposited the post as imposed by this court by order dated 8 September 2025. If a family court Karkarduma, where the proceedings between the parties are pending, is directed to initiate execution proceedings and not to entertain execution proceedings and recover the amount through lawful coercive means. So it is directed that no court in any city of Delhi shall entertain any petition on behalf of the petitioner unless the cost amount imposed by this court are deposited.
Apply. I have been removed from the trial court cases also, my lord. So I'm.
No, you can't do anything.
Completely.
As a counsel, you have done your duty.
May I please minutes? It's an integrated steel project. The government permitted me in 2 phases. In 2 phases, it was permitted. The first part concerns the raw material. We have established and it's been functional from 2010 onwards. For that purpose, land was acquired and that was quashed, the acquisition, by the Honorable High Court, and that was set aside by your lordships through a reported judgment. That's how we could establish. Then we have begun the second phase. Again, the same thing happened, Millets. Once there was a condition imposed on us that we should get 70% of the approval from the landowners. When we were in the process, within a couple of months, the Honorable High Court has stayed it. And now, Millets, I was non-suited on the simple ground that you could not get 70%, disregarding the stay by the Honorable High Court, which has been there until the disposal of the case. This is the problem I face, Millets. And in fact, what has happened, Millets, the land that's been allotted to me, and it was sought to be acquired. In that process, Millets, in the interregnum when the stay was there, the government wanted to give away.
Right, 2012. 2012 acquisition, these people who can afford litigation, they don't allow anything to attend finally.
Because of the stay that's been granted by the Honorable High Court, which has been there until the other day when it was eventually disposed of. I was incapacitated.
12 allotment.
Yes, Millets.
Challenged in 2016. By that time, land has been acquired.
It's not been acquired, Millets, first thing. It's been acquired for my sake.
First, it was allotted to you.
Yes, Millets.
With a condition that 75% consent.
Yes.
There you are having a case that yes, there was some litigation and there was stay, you may not have been able to pursue it. In 2012, a further 2-year extension is granted with a decision that hiving out around 104 acres. That is where your grievance lies. That with 104 acres of land, I cannot have the industry. So you should have assailed that order then and there.
Millets, what has happened?
AID is allotted the land by a valid acquisition process where section 6 is in 2014 and 2016 money compensation paid, etc. Now, what the High Court rightly observed.
Now, Millets,
we understand
that your land has been given to a private entity to
set it out. Millets, now the acquisition is not a problem. The land has been acquired for my sake. That's not the problem. Kindly have a look at the map, Millets. They have carved out 100 and odd acres in the middle of it to be given to another establishment. And then we have said, we have negotiated, we are willing to pay all the expenditure for that purpose. You can acquire to the next of it and you give it to them.
Land was not acquired. Land was identified and allotted. The acquisition took place when you failed to get 70% consent of the landowners.
Landowner.
And that is when.
Could my lords have a look at,
litigation under section.
my lords, could my lords have a look at the condition? The condition was imposed on 9/5/2008.
Right.
And Miller's stay was granted
Till 12.
in August 2008, and that continued.
Till 12. Till 2012.
Yeah, no, till 2014.
2014.
Yes, Miller. In the middle of it, this allotment took place in the face of the stay that's been granted.
Who is going to challenge it? You don't challenge it. You allow the state of affairs to change, and thereafter notification is issued under the Land Acquisition Act. The allotment is made, compensation paid, then you file a writ petition, or about the same time in 2016 you file a writ petition. Mr. Naidu, even if, let us say, you're making out a case of promissory estoppel. Let us say there was a contract. Still then, when you were not up and coming in challenging the breach of the contractual terms, will you get a degree of specific performance?
My lords, that's a very pertinent question. Let me answer. My lords have indicated there is a breach of contract. My humble submission is,
The case to that level.
at no point in time have I breached.
There is a contract.
At no point in time have I breached it, because Millets, I could not secure the consent because of the stay that's been granted. And Millets, now it is not the question of acquisition that's been in dispute. I could understand farmers have been agitating or whatever. That is not the question. The question is, from the land allotted to me, something has been cowed out.
Are you going to give back the entire money spent by KIAD till?
Yes, Millets, I have undertaken.
That undertaking has been discussed.
My lords, my kind for that issue.
Proposal.
Millets, we are willing, whatever that's been to be assessed by an expert, I'm willing. Otherwise, Millets, a project worth 54,000 crores.
100 odd industrial
Indeed.
units have been set up.
They have, Millets, no, nothing has been set up, Millets. Nothing has been set
Not
up.
it. They
Kindly
have
see
not
their
it.
affidavit, Millets.
Well, they will all their
Millets.
sheds and all.
Their affidavit, Millets, we have offered.
Even they can have a breathing from this
Millets,
litigation.
my lords may kindly appreciate one thing. The Honorable High Court has also given the same offer to me. I have said that I am willing to compensate whatever that is there, so that they could have it established to the next to that other land. And then, Millets, on the question of quantum alone, the difference was there. It is not that they don't want to give it to me. If my lords give a chance, whatever that's to be assessed by an independent expert, I am willing to pay so that the whole project becomes functional and viable. Otherwise, Millets, my lords may kindly see, they still have given me 800 and odd acres. I still have that one. With 100 acres in the middle of it, the project becomes unworkable, and the projected expenditure is 54,000 crores, the biggest in the state. So far, we have invested 5,000 crores. With this one, it will come to 16,000 crores. It's a win-win situation, Millets. Only thing is that, Millets, the authorities have to agree, allot this land, take the compensation for the expenditure they have had it, and then allot it elsewhere. Nothing further has happened. And they have filed an affidavit. We have got grievance with regard to the quantum, not otherwise.
Come to page 15 and 16.
Beg your lordship's pardon?
You are offering
Yes.
17 odd crores.
Yes.
They are saying
23 Millets. I mean,
that 17 crore that their acquisition and
that's for land and structures 5 crores.
totally 60 crores. They are
Millets,
60 crore.
what my humble submission is, let it be assessed. Millets, my word against their word, it leads us nowhere.
At least.
Could my lords indicate that let an independent agency assess that one? Millets, I have agreed to provide employment to each one of them. My lords, to that limited extent, kindly give a notice that whatever the assessment of the value, I am willing to pay. And Millets, two things, Millets. One thing, I was disabled by the order of the court, first thing. Second thing, I am willing to compensate them.
Politicians.
No, Millets, it is an industry that has had a presence for decades over there, and they have promised to invest 54,000 crores, and they have entered into MOU with the state allotted. Only to the limited extent notice may be given, Millets, that we are willing to pay whatever is the expenditure they have spent.
Thank you, Mr. Naidu. Court can't become party to this unholy nexus.
I'm afraid, Millets, it's a genuine project. Now the problem is the raw material production is been on, but I could not use it for the final production. I have to make it. I still have 800 acres at my possession, which was given by them. All that I want is take away that enclave of 100 acres, give it elsewhere. I'm willing to pay. My lords may kindly consider. It's an industry, not someone having the land at the cost of someone else. Could my lords consider, my lords?
Thank you, Mr. Naidu. Thank you
Great.
very much.
Deeply organized.
Your Lordship, this is one of those online gaming batch matters for the casino. The same order has to be passed.
They have issued already show cause notice.
Two, yeah. The order in original has also been, adjudication order has been
Order
passed.
has
That,
passed.
yeah, that has also been passed. So needs to be stay, no coercive, the same order Your Lordship has already passed.
Yes, we have passed an order.
Yes, Your Lordship. We've got.
There are two types of orders.
I'll give the order date.
You can give that one.
I'll give the order date. It is in writ petition 531 and 536 of 2026, dated 30th of April.
Show cause notice के case में under
We'll give the details, Your Lordship. Adjudication order dated is 23rd of December 2025. Obliged.
Yes, item 22.
My lord.
Yesterday, you would have said.
So, my lord, I filed a petition order under Article 32 of the Constitution, seeking the involvement of this court, indulgence court, to relook and reinterpret Section 13(2)(3) of the Hindu Succession Act, which, if I'm allowed to read out this, it'll just clear. Allowed to read.
What is your problem with that provision?
So my concern is that it should be open to both male and female.
No. What is your problem with that provision?
It's basically a gender-centric way given to a.
So how it is bothering you?
So me as
Who has told you be the chief contractor of all the males in society?
Yeah, just to establish that I am one of the sufferer.
You are self-acclaimed leaders of the male.
No, sir. I am a sufferer of the
Now you
matrimonial
are coming.
remedies.
This is what I wanted you to confess.
If
To understand that what kind of wife, we should not impose exemplary cost on you. You want to settle a personal vendetta through
No,
a
sir.
trial?
No, sir. No, sir. No. I'm just wanted to because my locus stance comes from the fact that I have been suffering a matrimonial litigation for past 7-8 years. Had a male should have a way of hope to get out of these litigations. It could have given them a hope because there are so many persons.
You require not only this provision to be declared ultra vires, you should have the constitution amended. There is one provision in the constitution which says that the state can make special laws for women and children. That also should be amended.
But special laws are there. It can
So this is a special law, sir.
So it can,
This species, that provision that you are challenging, that it is available for a wife to seek divorce in respect of a decree not being satisfied, passed against the husband. You are right. It is not available to the husband, but unfortunately, the constitution gives the state the power to make this sort of a law. So you have to have the constitution amended now.
Challenge that also.
You challenge Article 50.
Lordship,
clause
3. May I submit? It's more than that of amendment. It's a interpretation thing, and this honorable court has already done this in the case of Harsovalal, where they have removed the word adult male to give a wider perspective to the.
That was a completely different perspective. That's got nothing to do with Article 15.
This does need a consideration.
These are all provisions traceable to that constitutional special statute privilege.
But sir,
So,
the statute which this
You have
constitution.
pointed out a very important thing, but that requires a constitutional amendment.
So that
Without
constitution.
that, this law will be absolutely in consonance with the constitutional scheme of making special laws for women and children.
But sir, the special laws for women cannot.
This aspect you will better understand when by the time you will complete your law degree.
Yes.
Lordship, I understand it. But I feel like this court has the jurisdiction to take up
I
this.
hope that you are not joined law only to claim yourself as a student in maintenance proceedings.
No, sir. No, sir.
Otherwise, why? You are also, what did you do from the Mercedes University?
Huh?
MD University से क्या पास किया था?
So MD University से I did my BTech. I am a BTech graduate. And then because of COVID things and all that, I had like I
Good thing that you are doing law, nothing wrong in that. That's something we will always appreciate, that you are now doing law. And there is a, nowadays there is a very good.
Has he paid maintenance to his wife?
You see, nowadays there is it's a good trend that in law, people after MBBS they are doing law, after BTech they are doing law, after engineering they are doing law, after chartered accountant they are doing law. The combination is doing pretty well in profession also, in law firms also, in corporate entities also. So nothing wrong in that doing it. But don't have your personal vendettas through Article 32 set.
have any personal vendetta. This is going to serve almost half of the.
So, like, have you paid maintenance to your wife?
So,
have you paid maintenance to your wife?
So I have handed over my land itself to the wife. That's a subject matter of consideration, whether court consider it or not. I'm not hiding anything, but I've handed over half of my assets, what I had in my name right off. I've handed over.
Then fair enough, you have already done your statutory obligation, you have discharged well. Now you, whatever contest litigation you have, you fight over it. We are not saying so. You might be having some genuine grievance, Mr. Young person. We have sympathy with you, but we have equal sympathy for your estranged wife also. Both of you, if you, maybe that some court will ultimately persuade you for mediation and resolve this dispute. But don't fight this kind of litigation.
So this
does not send a good message for the law students. Wait for some right time and right opportunity.
Well, I hope this could have served the humanity a bit better, because the concept of de facto breakdown of marriage has been discussed by this honorable court, variable high courts, time and again. Maybe for some or the other reason the government is not taking up. I'm not diverting to that side, but I thought that this, being a gender neutral perspective, could have served a lot more perspective to the entire humanitarian aspect. It serves no purpose that after
law professors, they will advise you better. No place to entertain this petition without discussion.
May I please, your lordships? This is a case which is a statutory appeal, your lordships. It is the court of first instance, and this has been perfunctorily and cryptically, without even looking at my grounds, quoting EIA report. Out of 45 pages of the judgment, 41 pages is just a quote of the EIA report. And in one line, they say, we find everything to be in order, and they dispose it off at the admission stage. They don't even, and this is a first appeal, your lordships. This is a statutory appeal that has been provided. I had raised 7.
Also disposed of on the first date. There is nothing wrong in that.
No, there's nothing wrong, your lordships, but provided they consider everything. I had raised 15 grounds, taking every ground on both effect on fisheries, effect on biodiversity, and most importantly, your lordships, there was an EC granted in 2012, and for 13 years, they could not complete the expansion because of economic factors. And after 13 years of failure, they once again approach and get an EC for expansion. I'll just show that, your lordships. At least that should have been considered. Your lordships always says there should be sustainable development. If it's economically not viable.
This country, the kind of litigation these are filed only to stall all development projects. That is the whole problem.
Please look at just one page, your lordships. Just look at their own EAC minutes. Please look at one page, 187. Your lordships has 187.
You see, if people don't want ports to be expanded,
It's not there.
but how the country is going to progress, we can't understand this part.
Your lordships, may I just...
One should tell you, yes, development is necessary. We appreciate a person comes that these are the precautions required to be taken. Please go ahead, but make sure that these are the precautions you take.
Yes, has that at least been done by the first appellate court?
First attempt is you stall everything. And that sends a message from where the litigation is being originated. That creates problem.
No, your lordships. This is one such case which is now. Please look at page 187. Please look at 187.
You tell us what are the suggestion which the petitioner has made,
Yes.
appellant has made.
Yes,
Please.
if they had even heard it for at least issued notice and heard it, at least the
No.
No,
It's not that NGT has passed a detailed order, speaking order.
No, it has
After concluding.
detailed order, your
You
lordship.
see, after referring to the reports of the experts.
Yes.
And then in para 8, please see page
Para 8,
44.
what does it say, your lordships? It says it is evident from a detailed consideration made. EIA report is not a detailed consideration. EIA report is a first
Please
document.
tell us, would you please tell us what are those recommendations which have not been taken into consideration?
Correct. Please look at page 77, your lordships.
Yes.
I have in fact made a chart. Your lordships may look at the chart, which look at page 70, 71. What has happened today, your lordships may look at 71. What do I say? I say that the EC was granted. In fact, this expansion is not one of 2025. An expansion order was granted as early as in 2012. And for 13 years, the only component that they have finished is a first aid room. And why do they
This lesson, the EIA does not fully characterize potential impacts of dredging on marine ecology, inadequate sediment sampling of.
Can I just say why?
The things which up to post-development activities are required to be followed.
Your lordships, may I just say why we are truly aggrieved? This is actually an extremely rich area for fisheries in Gujarat, your lordships. 90% of the fish landings happen in Saurashtra. If a project after 13 years could not take place, for the asking, they have given them an expansion. And is a first appellate statutory appeal? Is it supposed to be? It's supposed to do a merit review. It is not supposed to do a judicial review. This can't even constitute a judicial review. They have not looked at any. If something is found to be economically unviable, why after 13 years have you once again given them an expansion? Please look at page 187.
Madam, that may not be a very relevant point for an impact assessment.
Sorry, your lordship.
And economic viability.
Yes.
Is not a real consideration for anyone.
If it is found to be economically unviable,
reasonably expecting inflow of funds.
Yes.
Seeks environment impact assessment.
Yes,
correct?
please. Yes.
12 years ago.
12 years.
Impact assessment made with conditions permitted.
Correct.
He is unable to arrange funds and thereby put his project into operation.
Please look
Will that be a ground to disqualify him from a fresh application?
No. But if it is please look at what the
basic thing was, it's a turtle nesting site.
It's a
that is not found.
No, that's I'm glad your lordship has asked that. Please look at the 2 pages. The EIA report at page 3. I'm glad. I didn't want to get into so many details. My difficulty is if they had at least considered my appeal on merits, I would have been happy. You non-suit me. But do not give me a 1-paragraph response in a court of first instance. Look at all my grounds and reject me. That also has not been done, your lordships. It comes at an admission stage. You cut paste. Look at 44 pages.
That's you're being a bit too harsh.
No, but
what they did, they set out the entire EIA.
EIA is that the document which is sought to be appealed? No. EIA
inspection report.
Yes.
What you said that, look here, they have given the EIA.
Yes.
They have not considered ABC.
Yes.
Now, one of the main areas I'm rightly indicating would have been a very serious consideration for NGT had it been a turtle nesting.
Please look at what I'll answer that
now
question.
They say that look in the inspection report.
Yes.
Inspection report unequivocally says that this is not a turtle.
It needed to be a turtle nesting site. What
that is page 3 of the 44-page order.
Please, I'll answer that straight away. Please look at page 3. What does it say? There are no turtle nesting grounds in the project location. Page 4. Marine mammals are not observed near the project region. Now, the very annexure which was filed to this EIA report, which was a CSIR NIA report, finds to the contrary. No, finds to the
Come to
contrary.
page 347.
Yeah,
See.
348.
Yeah.
Yes,
Right.
347. Yes, please look at 348. It says list of marine mammals reported from the study area. Olive ridley turtles, humpback whale. Look at the list of mammals that have been given.
Right.
And what does the EIA report say? Yes, I understand. Page 347. bottom.
4.1.
Yes.
That paragraph.
Yes, your lordships, according to, but these species have been reported near, but their occurrence in the study remain rare, transient, occasional. That may be,
No,
but
understand.
can
Just consider.
Yes.
Since you are much better aware of environment than,
no, your lordships.
but
I don't
just
claim.
see the situation.
Yes,
You are seeing an assessment of a water body,
correct,
which is the sea.
right?
So a marine mammal would naturally, there can be a transient movement even of a humpback whale.
Yes.
Will you say that the humpback whale nests there?
No, it needn't nest.
Maybe a rare sighting of the whale.
It needn't only nesting breeding sites are one parameter. What do they say? No marine mammals found in the area.
These species have been reported from nearby region.
Yes.
But their occurrence in this study area remains rare.
Yes.
Transient and occasional or incidental.
Please see the next page. What does the next page say? Your lordship,
these are possible.
Your lordships, may I just say this?
This is river dolphins in the Ganges.
Yes.
At one point of time, you could see even river dolphins near the city of Kolkata.
Yes.
But now it's a rare occasion if you find a river dolphin.
Yes. Why is that? Your lordships, why is the question that we need to ask?
That is another question.
Yes.
But let us say this is the state
Yes.
of affairs when an EIA is required. And the EIA report says that it would be wrong to say that he won't ever find a river dolphin.
Yes.
But it is very transient.
Yes.
So in this
Transient,
situation,
some
how can we
species.
say that
Your
the
lordships,
application of mind is
no,
wrong?
your lordships, may I just say this? What
Is what you are saying, that it's not a case where there will never be an olive ridley turtle there or something.
And what have they said?
Public-private enterprises, and if you come to page 280,
Yes.
just see how many experts are involved. Please.
No, absolutely. I am, your lordship.
Page 281.
Yes.
Do you think NGT is better than these people?
No.
Then
But what is the job? No, but what is the, today what am I asking? Your
Not a
lordship,
single field
may
on
I?
the earth is left where the experts of the highest rank are not associated.
Yes, can I just show?
14 experts,
Correct.
each one of them.
Your lordships, I cannot.
Then see,
I cannot
functional area
join-
issues,
I
team
can-
members.
Yes, I cannot join issues with your lordships at all.
Maybe, see,
I am
ultimately,
only
but
saying.
you are also state, you went to NGT, and unfortunately that sometimes create a lot of doubts on bona fides. You don't go to any expert agency, you don't go to any authority pointing out that, look here, this is your report submitted. I am an expert. I find that these are the deficiencies in your report.
Correct.
If at all you are expert, you are some RTI activist, you are so-and-so activist, I am an environmentalist.
I live there.
You possess so many degrees. I am RTI activist, I am environmentalist, I am social activist, I am so-and-so activist. So, kaam lage wahi.
Nahin, your lordships, is there anything wrong with us? As people, we also inhabit this planet. We are also entitled to those. Your lordships, make it in a lighter way.
You are
I'm not
standing up for
today,
everyone that we understand and we appreciate.
He should have done one thing.
That
this EIA report,
right,
as a bona fide person, suppose he's an expert on this.
Yes.
We could point out that, look here, you have done a commendable job.
Yes.
Despite that, these are the deficiencies I can notice in a report.
Right.
Make sure when you execute the project, these things are also taken care. You could go to some government agencies, you could go to the environmental authorities, you could go to this EIA itself, that you must look into these aspects. You rest to the NGT. NGT has examined this report overwhelmingly and came to the conclusion that all your apprehensions have been taken care.
If it had,
In any case, the doors are never closed. If you find that during the execution of a project,
But can I just say this? I would not have come because let me tell you, when 2012, when the expansion was granted, there was no challenge to it, Your Lordship.
You show us a single project in this country
In
where these alleged environmentalists, activists, they say, we welcome this project.
Can I just say,
Eh?
Your
The
Lordship?
country is progressing well, we welcome this project.
Incidentally,
Everything you
no,
drag to the court.
I have some data. The number of projects that are approved, it is less than
Do you think country doesn't need bigger ports?
that go to NGT.
Has anybody examined which part of the sea in India,
Yes.
which part of the area, sea has the requisite depth for bigger ships? Has anybody examined the environmentalist?
But
And how are you going, unless you have the ports in those areas, how are you going to have
Your Lordships, there's all. May I just say?
we are at the same time equally critical of the environmental issues. No question of compromising on those things.
That's all I'm saying. What am I saying today? In fact, I thought today I'm asking
Could
for the
you
most.
please tell us, this petition appellant,
Yes.
did he approach a single authority?
Yes. Can
Please
I just say he himself appeared before the public hearing.
Hearing.
That is no, but that is one way to ventilate. That is what the statute permits me. I have gone before the public hearing. Your Lordships, the fish catch. In fact, 80% of fish landing in Saurashtra happens in this region. And there is a detailed impact on the fisheries, both at the construction stage and the operation stage. What am I asking today? Is the only that the NGT should have looked at my petition in
You are asking to stall everything
No,
so that
Your Lordship, there's no
bigger ports don't come in this country and all business goes to the neighboring country. You are the competitors.
No, Your Lordships. I wish Your
But
Lordships.
unfortunately,
No,
things happen.
then Your Lordships may look at what they have done for the last 13 years. Please look at, Your Lordships, please look at page 187, just for a minute. It's very interesting. Your Lordships may just be satisfied. Let me at least endeavor.
Tell us who are the authorities who can examine these suggestions at page 71, 72 and 73.
One expert member is there in the NGT. Out of 15 grounds, all I'm saying
One
is.
expert member, he can't do anything when
No.
21 expert members have given the report.
But that's why merit review. It is not a judicial review. In fact, the decision itself should be looked at. What am I saying? 3 months, let them decide my appeal. Then let them non-suit me. But not doing a cut paste, of an EIA report, Your Lordships. I am only saying let them consider, throw me out, but not perfunctorily, not on day one. In 13 years, they haven't done it. And now for the asking, they've got an expansion. Please look at their own. They say it is not financially feasible. And 600 acres of village land will go in this. At least the NGT should have looked at everything.
Port can't be developed on inches.
It can't.
Square meters. Port requires hundreds of acres.
Correct. Yes, Your Lordships. But for 13 years, they didn't do anything. Then if they want to have at least a change of circumstance, at least that should be seen before you want to proceed with the most fertile. In fact, Justice Bakchi would know, Bombay duck, which is one of the tastiest fishes. Most of the landings of Bombay duck takes place in this region. Right. In fact, I'm only saying let the NGT consider my appeal and then give me a reasoned order, Your Lordship, not a cut paste. That's all I'm saying. Let it be 3 months.
Reasoned para 8 is definitely reasoned. The appellant approach the National Green Tribunal from West Bengal bench at Pune, challenging the grant of environmental clearance and the report of environmental impact assessment given for expansion of the Pipavav port in the state of Gujarat. It appears to be a public-private joint venture.
It's private limited. No?
The NGT has wide impugned judgment dated 26 November 25 dismissed the appeal at admission stage after elaborately relying upon the EIA report in which various aspects have been seemingly examined by a team of experts. The aggrieved appellant is before us, entirely alleging that, regardless of the EIA report relied upon by the NGT in dismissing his appeal, the EAC has failed to consider the following aspects. Page 71, 72, and 73. This will be serial number 1 to 13. Next paragraph. Though we are not inclined to agree with launching a counsel for the appellant that the tribunal, that the NGT has dismissed the appeal without assigning any reasons, nevertheless, we grant liberty to the appellant to move a review application before the NGT, specifically raising the above stated grounds, specifically to point out that, specifically to point out as to whether or not the above reproduced issues raised on his behalf have been duly considered by the EAC or the experts, by the EAC or in the EIA report,
EAC is actually the right, your lordship's absolutely right, because finally the EIA is seen by the EAC. The appraisal is done at that stage.
We request the NGT to look into this aspect of the matter. It is clarified that we have not expressed any opinion on marriage. You try your luck there. They are better experts than us.
Well, your lordships, I must have a liberty to come back. If
No,
they
don't
don't,
come back. Don't,
your lordships is,
don't come back before the
no,
before the known experts.
that is legally available to, I mean,
Allow this projection. What happens initially, sometimes we have apprehension. Those apprehensions can be genuine also. We are not saying on the lighter side we may say anything, but apprehensions can be genuine also. But never do that everything should be stalled. Country can't progress.
There's never been a stay.
In the process of implementation, make sure that all precautionary measures are adopted. Precautionary principles are always followed. Those are required to be followed also.
I'm obliged.
Make sure that.
I'm obliged.
Thank you.
It is one of those rare cases where we specifically say there is no arbitration clause. Now, kindly come to page 6 and the dispute of
the High Court has exercised the discretion.
2013 dispute.
Concession, on concession, paragraph 23.
Though Mr. Shakil, that is my counterpart, submits that this is the second round of litigation between the parties, and earlier this court had appointed the arbitrator for a work order, but now the applicant wants to review the order by including other claims which have already been considered, this petition may not be maintainable. But I am opposing it. And if your lordships come to page 6, we say specifically that earlier arbitration appointed was abandoned, and here there is no arbitration clause. Page 6, my lord, somewhere.
But that will be a plea available to you before the arbitrator.
2013 work orders, my lord. Please have a look at page 6, my lord. The limitation, now, my lord, there are judgments which take the view.
The point is that we have to hold that there exists no dispute. If we set aside this order, that means we will have to hold that there exists no dispute between the parties.
No, my lord, your lordships may have to.
Isn't that finding be given by us? You can always take a plea before the arbitrator that there is nothing for you now to adjudicate.
Your lordships may have to give a reason, my lord, give the finding that there is no arbitration clause. That's my case. My lord, section 11.
No, the arbitration clause is there.
No, there is none, my lord. That's my case. So what has happened is, give me 2 minutes to explain. There are several work orders. In one work order, there was an arbitration clause. There, our arbitrator was appointed. I'm not going into the limitation, but it was appointed. Arbitrator was appointed. He abandoned it.
Parties. In one case, there is already arbitration proceedings going on or
Abandoned. I'll show the order. Now, there are several, kindly have a look at. First, this is something extraordinary. Page 5.
yes.
Page 5, somewhere 6th line from the bottom. Otherwise, I would not have pressed it. Relying upon submissions, your lordships have seen.
There is
6th or
5 of
7th
the paper book or
of the petition, impugn order. Relying upon submissions, it's a half sentence. I don't wish to read the entire, but that would take. Learned counsel further submits, your lordship gets. Learned counsel further submits. Page 5, it's a part of para 6.
That's right.
Yes. 8th line from the top. Procedure, learned counsel further submit
Submit that the petition
that the
merely
petitioner
relying
is
upon.
merely relying upon submissions made by the answering respondent in an earlier writ petition acknowledging the existence of an arbitration clause in a particular contract, pursuant to which this honorable court had already appointed a sole arbitrator, and the arbitral proceedings were subsequently terminated at the request of petitioner himself. Therefore, no fresh cause of action for invoking arbitration survives. Now, this is important. It is further contended that present petition is vague, ambiguous, lacks so-and-so, as it does not clearly identify the particular contract or arbitration agreement under which the relief is sought, nor does it specify the disputes proposed to be referred to arbitration. The applicant has raised an omnibus claim of rupees so-and-so by clubbing multiple invoices allegedly arising out of different work orders and even different mines without demonstrating their nexus to any single arbitration agreement or identifying the contractual provisions allegedly breached. Kindly come to the next page, my lords. And all these invoices do not have arbitration clause, different work orders. Kindly come to para 7 at page 6. There was one arbitration clause, arbitrator was appointed, it was terminated at his behest.
Now, where is that termination part?
Yes, Lord. Before that, can I only show, since your lordships are on the impugn order, my lord, there is something relevant, para 7. Then I'll take to, my lord, that order, my lord.
No, impugned order, we don't require anything except to refer where your own concession is there, para 23.
Arbitration clause is contained in the general conditions.
No, therefore, I wanted para 7. Therefore, I wanted your lordships to read para 7. My lord, kindly have a look at.
Mentioned.
My lord, only the no, my lord, may I try and factually, my lord, remove that impression. Only the first work order, where the arbitrator was appointed, contained GCC. Others do not contain even that.
But the GCC will be the underlying.
No, he has not. He has not produced. Kindly, my lord, para 7. If your lordships can, my lord, allow me to read para 7. Mr. So and so, my lord, the Chief Justice is para 7. Mr. So and so submits that from a perusal of the petition, particularly para 3 and 3.1, it is evident that petitioner has set up 14 purported claims arising out of different alleged contracts, including contract dated, my lord, all are 2013, my lord, and one is 23. Each giving rise to separate claims. Further, 5 claims are stated to be based on undated contracts, and 2 claims related to refund of EMD and security deposit without reference to any specific contract. From para 3.1, it further appears that reliance has been placed upon 21 documents, including certain orders of this honorable court, wherein the respondent company had acknowledged existence of an arbitration clause, please mark, in the contract dated 13 June 23. I am not disputing this. There is an arbitration clause in one of the contracts, my lord.
Three of the contracts.
Can you allow me to read further, my lord?
21, 6, 4, 7, 16. That's your submission.
Further, may I read, my lord, further? Which had already been referred to arbitration earlier, and the proceedings therein stood terminated by the learned sole arbitrator. Apart from this, only 3 work orders, contract documents dated so and so have been annexed, and even in these documents there is no reference to applicability of general conditions of contract or to existence of any arbitration clause forming part of the agreement. Thus, except for the contract dated 13 June 2013, which has already been referred to arbitration earlier, no arbitration agreement is shown to exist. It is further submitted that no notice under section 21 was ever issued invoking arbitration in relation to any of the said contracts, and even otherwise, please mark, my lord, there is a judgment that limitation section 11 court will have to see. So the limitation period for invoking arbitration, if assumed without admitting, has long expired. 2013 issues, my lord.
That issue will be decided by arbitrator.
No, my lord.
Limitation, what we will see is section 21 limitation, 21 notice limitation. But Mr. Solicitor, you are right. You are right. What submission is made is here, but you come to page 254, paragraph 6. The first reference made in the writ appeal.
Yes, my lord.
Here your affidavit in counter affidavit
Yes.
encloses a general conditions of contract clause 93. There also what happened, this litigant was unable to furnish the original contract, 13/6/2013 contract. But you in your counter enclosed that contract and also the GCC where clause 93.
May I clarify? That was only with respect to 13/6/2013, based upon which arbitrator is appointed.
Mr. Mehta, please come to page 8, para 9.
Page, my lord?
Page 8, para 9. Para 9 of the influence judgment.
Yes, para 9. Yes, my lord, Mr. Further submits that the present petition is barred by principle of finality attached to the earlier order dated 12/11. That was for that one contract. Yes.
See, please read.
Yes, but proceeding, the applicant has already placed before this honorable court the same set of bills, invoices, and the same factual metrics which are now being relied upon by the present petition, in the present petition, including invoice so-and-so claiming relating to EMD, SD, along with certain work orders, work completion certificates, and connected documents. After considering the pleadings of both sides and applying its judicial mind, this honorable court, by reason and speaking order, concluded that an arbitration clause existed. Well, that is that 13th June, my lord. Only with respect to agreement stroke work order number so-and-so dated 13/6/2013 and expressly confined the reference to the dispute arising out of the said agreement. Now he says there are several work contracts, there are several work orders, and of different dates, several different mines in the country.
Just see that earlier you were saying that that claim was abandoned. It is not abandoned. See the next line.
My lord, page 269, my lord. 269 is the order.
Now, pursuant thereto, the learned sole arbitrator, Justice so-and-so, appointed in so-and-so by order dated 4th March 2025.
Yes.
Passed in arbitration number so-and-so, recorded that the applicant sought liberty to file a proper petition before the High Court.
Correct.
And accordingly terminated the arbitration proceeding, leaving the parties to bear their own cost, because he wanted to file a comprehensive petition with respect to all the.
Would your lordship see that order at page 269? He says wherever in other mines I had work orders in etc. etc. Now I want a consolidated arbitration, which is not, my lord, permissible, but that's a separate issue. Now please see 269. The arbitrator doesn't give him that liberty. All right, you terminate the clause, my lord. Please see the last part, my lord. Order dated so and so passed by. Page 269, my lords. Well, 2013, he, my lord, wakes up after. So, and now there is a judgment of your lordships that at least limitation and existence of arbitration clause has to be seen in section 11. It's not just a post office. That's, my lord, the expression used. That section 11 is not just a post office. You have to see at least these two. Lord, order dated, your Lordship said 269, my Lord. Order dated 12/11/24 passed by the Honorable High Court in arbitration number so-and-so is very specific and relates to agreement work order dated 13 June 2013 as per submission by the petitioner. Total valuation of work order is rupees 11 lakh, but his total claiming would be more than 4 crore. As per, now it's 11 crore. As per para 10 of the order, remuneration would be settled with mutual consent. At this stage, petitioner submits that he wishes to file proper petition before High Court for seeking arbitration of his entire claim. Wherever there is a dispute, he wants.
Data come to page 265. But before you read paragraph 9.3 and 9.4, just see page 266 also.
Yes.
266, this person this respondent is filing every case in person.
Yes.
Right? So one has to give some margin to him. Now come on the left hand side, paragraph 9.3 and 9.4.
My Lord, I'm told, no, since your Lordships are there, on my Lord, page 266, he filed criminal writ petitions also. After arguing, my Lord, I can place, he withdrew those writ petitions also. He could not persuade the High Court. So now, my Lord, suppressing this, he comes under 11. Well, 11 is not just, my Lord, a post office.
Absolutely no. Absolutely no. But there is an admission by your client of an underlying general conditions. Referring, now, general conditions, Mr. Solicitor, we have to give the expression general some reference point. It can't be only governing one contract.
May I answer?
It should govern all contracts.
May I answer?
The parties when they are GCCs. Now, in this situation, if the reference has been made, with regard to the point of limitation, we will give you leave to take out an application for section 16.
Well, may I answer that? The work order of 2013 for which arbitrator was appointed.
13/6/2013.
13th June, my Lord, that specifically mentions that general clauses would apply. In other work orders, it is not mentioned. So if it is mentioned in one and not in others, well, that means it is not intended to be made applicable.
So if the principal agreement between the parties contain, then every work order does not require.
No, there is no principal agreement also mentioning general conditions.
GCC is the principal agreement which will govern all contracts or work orders until and unless it is expressly excluded.
Well, GCC is not an agreement. It's kind of a.
It's a condition.
It's a condition.
These conditions attach whenever the public entity enters into these work orders, so that there is no repetition of these conditions. Now, you are absolutely right. There may be individual fact situations where the GCC will not apply, but that must be expressly stated in that work order, isn't it?
That's what we have said in our reply in this proceedings before the High Court.
Where is any work order do you have that this GCC will not apply?
Page 7, no? That's why I wanted your.
No, page 7 is submission, sir. We want to see the work order. Then
we can place it. We can place it.
Please place
Definitely.
it for us, making it clear that 13th.
I understand.
You understand?
That 13th June also we will place.
This is how there has to be work orders. Yes.
My Lord, my Lord, the Chief Justice has used the correct
Conscious
expression.
exclusion. Conscious exclusion.
That in one there is inclusion.
Yes,
that means in other it is conscious exclusion.
Yes, yes.
Well, my Lord, kindly give me a week.
Counsel for the petitioner seeks and granted. It is time to place in the court additional documents to depict that the arbitration clause contained in Journal
90/93 of GCC. With the other contracts.
Work contracts. Some of the other work contracts. Post for further consideration and so on.
There is, I'm just flagging it, there is one judgment of your Lordships which says that merely GCC having an arbitration clause will per se.
We are conscious of it. There must be specific reference.
Yes, I am good. Would like to.
Your Lordships, seeking an adjournment in the matter. We are being led by. Your Lordships, we are being led by Mr. Gaurav Agarwal, Senior Advocate.
Justice Oak in Karnataka.
Your Lordships, we are being led by Mr. Gaurav Agarwal, Senior Advocate.
Sorry,
He is on
why
his legs.
file it? Now you are looking for, you want to engage some senior counsel from here and there.
Your Lordships, he has already been engaged. He's on his legs in court and post-lunch. She's in some difficulty.
Pass over.
Your Lordships, post-lunch, she's in some difficulty. Your Lordships, may I have it on next Monday?
No, nothing. Next Monday. We are dismissing it.
Your Lordships, may pass it over then. Your Lordships, may pass it over.
Pass over. All right. You file frivolous petition, then torture us.
Lord, item 26 is connected with 63, my lord. That is the earlier petition. Yes, that's it.
Lord, this is the case where two affidavits are required. One affidavit is filed. It's complete, Lord. Your Lordship, remember there's a conflict between Justice Kabir's judgment, Lord, and Justice Lokul, but we'll come to that later. Lord, have a look at the section and what is filed after Your Lordship's remand. Yeah. Would Your Lordship, just have a look at, see, Lord, the section first. Section 83. Copy to the page. Kindly the RP Act, please. 83. Yeah. Now, kindly, Lord, have a look. The High Court, Lord, has mixed up everything. Your Lordship's remand was very specific. The High Court has mixed up everything, which I will show, Lord. But first, let's see the law and what was done. Then we'll go to that. Kindly see, Lord, section 83. It's not technical. No, it is me, my lord. This is an election petition, my lord.
Yes.
I am the returned candidate, my lord. I am saying that the election petition must be rejected straight away, without anything more. My lord, just have a look at section 83. Kindly not see the section. This, my lord, the Chief Justice, my lord. Would your Lordship just see 83?
Oh, this is that case where margin is too short, I think. So,
No, that's another case, my lord, where we bother the Lordship after some time. That's another case. That's another case. That's the margin case. This is not that. Now we will turn to 83. 83 says, my lord, see, my lord, C first. It will be signed by the petitioner and verified in the manner laid down in the CPC for verification. Now, for this purpose, you have to go to Order 6, Rule 15. Just go to that for a second, my lord. And keep this open. See the Civil Procedure Code. My lord, in the old days, your Lordship will remember when we used to file written statements, they were only on verification. No affidavits were required. In the old days, I'm talking, my lord, in 70s and 80s. Later on, because people used to tell lies. People used to tell lies and they could not be prosecuted, my lord, because of non-affidavit.
This is to our consideration.
Yeah.
None of the judgments have considered it earlier. You see, this amendment came before the amendment of the Civil Procedure Code in 1976.
Correct.
The verification or the difference between a verification and affidavit was done away with.
Correct.
Was done away with. And that is why when you see the amendment of 83, section 83, which was in 1961,
yes.
And it says that you will have to have a verification as per CPC.
Correct.
And in respect of corrupt practices, you should have an affidavit.
Correct.
The reason, Mr. Rohatgi, our at least tentative view is because in 1961, the verification under the Civil Procedure Code was significantly different from an affidavit.
Correct.
But now, the verification as per the Civil Procedure Code is by way of an affidavit.
So that's, I say, my lord, therefore,
if that is so, then two affidavits
are required.
A redundancy.
Right. Two will be required.
And this
No, then-
stayed with us.
Lord, your lordship, it is.
Therefore, we remanded the matter that please see whether there is substantial compliance of 20.
Lord, with great respect, I'll show you that affidavit which is on record. But my submission is under 83(1)(c).
Consider this state of law.
Yeah.
When the incorporation is made in 61 vis-a-vis the civil procedure code,
Right.
and the change in civil procedure code in 76.
So how will it be?
When we read it today, in the manner laid down by the civil procedure code for verification of pleadings, there is no significant difference in the verification of pleadings in the civil procedure code
Now-
post 75,
So,
post 76.
So, my lord, with great respect, my lord, with great respect, these issues have arisen earlier, that this will apply on a particular basis. If that basis changes, you have to look at the change. Girnar, yes, give me Girnar. Give me Girnar.
See what 87 of Girnar says. See the big part. If there is a specific section mentioned, it will be frozen in time. But when it just says the law verification of pleadings, then it will be including any subsequent amendments. And this local says I'm not going into. That's why we don't know. It's fine, Judge.
So, give Girnar. Now, I just not complete my submission. I appreciate what your lordships are saying. But there is a constitution.
You have to notice this now.
Young lady,
There is a constitution bench answering what Justice Bhakti
there
said.
in this matter?
If there is a reference to some other law and that law changes,
Item
then you will have to look at the change law is below Girnar.
Exactly.
There is a
Please,
judgment
Your
to that effect. Constitution bench of this court.
Mr.
So two
Aditya.
affidavits.
Mr. Aditya, the only
see the affidavit
that we are inclined to make is that permit them to file the counter amended written statement.
Your Lordship, in item 26, no notice has been issued and we've not been served with the
That's right,
SLP.
High Court has become just too technical that let them file the amended written statement, that's all.
My lord, may I, in item number 26, which is a connected matter. Now, what has happened is, after almost 6 months of passing of the orders by this honorable court directing expunging of certain portions from the election petition, which would have rendered it effective, my lord, they filed the amended petition, and under the guise of amended petition, they completely changed the nature of the election petition without even filing an application for amendment.
That
My
is
lord,
precisely argued for the High Court.
Much obliged, Your Lord.
It's a subsequent thing. First thing is whether you require two affidavits of one. In Girnar, your lordships have said that if A refers to B law and B law undergoes a change, then the change position will have to be seen is below the answer to verification and affidavit. Number one. Number two, the second affidavit below has to be for correct practice. See the affidavit which is filed. One affidavit, it meets neither.
These are all arguments. Once you will file the amended written statement, issues will be framed and the election tribunal will go into these things.
Beloved, with great respect, your lordships have always held that if the requirement of the law is not met, the EP must go. Beloved, it can't.
Your Lordship, the
High
High
Court-
Court has considered these arguments
and we
and the
see
High
below
Court
the
has
affidavit.
stated that there is material compliance. In fact, when your Lordship sees the impugned
Have a
order,
look at the affidavit which is filed. Just have a look at the affidavit.
your Lordship may look at the impugned order, Your
Your
Lordship.
argument, in fact, is going against the purpose of your petition.
Much obliged, Lord.
Did not incorporates the requirement of an affidavit by way of the amendment to the Civil Procedure Code, then if instead
Girnar
of...
is not on this law, Lord. It's on some other.
No, Girnar is on Karnataka law with regard to land acquisition.
That's
Land
right.
acquisition. That's correct,
Yeah,
Lord.
conscious of it.
Yeah, I know. So it's not this one. Yes, correct.
You're not that innocent of law.
Yeah. No, I didn't mean that at all.
The issue is this. If, and that is what had weighed with us on the earlier occasion. It is a fact there is one affidavit.
Yes.
It is a fact that you had argued that it did not comply strictly with Form 25 because there was a collation of paragraphs in one with regard to knowledge and with regard to
information
of the information.
Yes.
So it was remanded. Please examine whether there is substantial compliance.
Right.
That's correct.
The High Court holds there is substantial compliance and has given certain reasons. One of the points that you are again re-agitating is there is no compliance because there is no twin affidavit.
Right.
There is only one affidavit.
Right.
Our response to that is, to us, this is substantial compliance because now the verification is akin to an affidavit. And therefore, how can there be non?
I am saying, my lord, that now the CPC requires verification plus affidavit and current practice requires affidavit. So two things.
So if the CPC requires verification
and affidavit.
Verification by way of an affidavit. Earlier, verification did not require the affirmation.
Right.
Right? That I solemnly affirm.
Correct.
Now you have the verification in the form of an affidavit.
Right.
If that is so, the entire body of the election petition is sworn by way of an affidavit.
Yes.
And the requirement of a second affidavit.
Yes.
And if it is not there, the question of perjury and holding a person accountable for pleadings will continue to subsist in light of the earlier affidavit.
Because of one affidavit.
Yes.
Only now.
What we are telling
all right. Let's proceed that way.
So we are not really wishing to interfere the order on the twin affidavit question.
All right. Let's
the other issues are
let's leave that.
limitation and B of the addition of certain pleadings.
That's the second part.
Madam indicates.
Yes, what my friend is saying.
Yes.
But all right, let's proceed on the basis that one affidavit is good enough. Right? Have a look at that affidavit. It is not complying with either the first one or the second one. Have a look, my lord. Turn to page 186. Just have a look. You can't file my lord a petition like this. And the High Court gives the reason that the registry has not raised an objection. It's the registry to raise an objection. The registry hasn't raised, therefore it's fine. I'll show you that. How can that be, my lord? Registry can't decide, my lord, admissibility of affidavits.
Turn to the tag matter. There are two forms. Let Mr.
I'll show the forms.
The two forms. One is under the Odisha High Court rules. One is under the CPC. One is under the RPI. Therefore, the two forms are different. The two forms require two affidavits, separate affidavit. He files one affidavit which does not comply with the Odisha High Court rules form, nor does it comply with the RPI.
With the RPI.
There are two.
Let me show you the two forms.
One affidavit.
Then have a look.
One affidavit.
Copy to
the form. The two forms are prescribed.
Kindly, my lord. See this, my lord. Kindly have a look at this.
Kindly see the Odisha.
I'll show you the two rules and then the actual affidavit. According to me, there is non-compliance of everything. Kindly, my lord, see. This is the Odisha High Court rules. Kindly, my lord, see.
Lord, I have got two forms in a
We'll be examined that. Now, my lord, kindly see the second page.
Why this return candidate is so apprehensive of, let the election petition be tried on merits and decided.
My lord, your lordships have always said that for at least these line of cases.
Otherwise, the very election petitions are frustrated on such hypotechnical grounds. We have already given a chance to the High Court. High Court has examined it. That's all.
High Court is not considered that two forms are required.
No, it is considered in the impugned order.
Forms are different forms. These are statutory forms under the High Court rules and under 83(1)(c) proviso.
And my lord, my written statement has been foreclosed.
No, written statement we are permitting now you to file. That's what we are
That's not
saying.
acceptable.
File your amended written statement and whatever objections you want to take, get the issues framed there and then lead the evidence.
Kindly compare the two forms, Bhagat.
Your Lordship,
Have a look
the
at
written
the-
statement
Milord,
be
what has
filed on a
happened is-
time-bound manner, Your
Have a look
Lordship.
at the two forms,
That
for
the
one second.
proceedings don't
Kindly
keep
turn to
going on
page 2
forever.
of what I have given. Page 2, these are rules for affidavits. Milord, your Lordship will find, see, Milord, the last line of the second page. Affidavits shall be filed
In the following format, yes.
in the following format. So, Milord, now format is mentioned. In the format, Milord, your Lordship will find the declaration, true to knowledge and true to information received from following source. This from following sources. What are the sources? This is one affidavit. The second affidavit, Milord, under the RP Act, this, Milord, your Lordship will find
knowledge
sec. RP Act. This is the RP Act. No, RP Act guy. Should be good RP Act. But it is not put both together.
Kindly compare the two.
Now, this affidavit and the RP Act requires an affidavit. That is Form 25 in that book. In the book, if your Lordship will turn to page 304. 304 will out of this book. Your Lordship will find an affidavit. This is the affidavit required, Milord, for current practice. It's here. See, Milord, Form 25, Rule 94A, page 304. I so and so calling in question the election of so and so. Make an affirmation that the statements.
Yes.
I so and so in the petition calling in question the election of so and so make a solemn affirmation that the statements made in para so and so of the petition about the commission of corrupt practice of so and so, so and so, so and so, and the particulars of corrupt practice mentioned in paragraph so and so of the same petition and in paragraph so and so of the schedule are true to my knowledge. B, that the statements made in para so and so about the commission of corrupt practice of so and the particulars of corrupt practice given in para so and in para so schedule are true to my information. This is completely different from the affidavit plot which we normally have.
Is it different? If you compare the two, please compare the Mr. Chidambaram and tell us, apart from paragraphization of the two, is there any difference? The two in the Orissa rules are conjuncted by an and under Form 25 are divided into A and B.
There's one difference. One difference.
Because
in the High Court affidavit, which is in the compilation I've given, it says that you have to give the resources.
Here also you have to give the sources. C.
Just look at this.
Please, true to my information, C, D.
It doesn't say source.
Are the sources.
Just have a look at this.
And if that is so, Mr. Rohadri, then the affidavit of Odisha rules actually ask for more information than Form 25.
Correct. Absolutely correct.
Yeah, and in this case, the affidavit included the sources. Your argument is sources are vague because information was received from lawyers, names are not there. That's all.
Have a look at the affidavit.
We understand that election petition and law relating to election requires strict compliance. But again,
technical law, but then
that's a beautiful word used by one of the judgments. It is technical, but not hyper technical.
Correct.
That's the word used.
Just see, I have been informed by my respective polling agents. What is this? This is
given the name. They have given the name. Your polling agents are all there. Your names are all there. Available.
They are at pleading stage. They ultimately, based upon this evidence, might be accepted, rejected. That's for the election tribunal.
Your statement is compiled by my advocate.
Mr. Vivadi, we'll leave it.
Then give us time to file.
Yes, she has a point.
My lord, allow me just 2 minutes. My lord, just...
Tag matter, your lordship remanded it to the same judge to be heard together, but separate judgments may be followed. The office report says my tag matter is tagged my opposite, Mr. Robert D's case, but it's not listed today.
Where it is listed?
It's not listed. It's not listed. The brief is not there. The status report says tagged matter. Says tagged matter.
On Friday, Mr. Chidambaram.
No, it's tagged to Mr. Rohit. If your lordship.
No, it is not tagged. Tagged are only two matters of the same between the same parties, 26 and 61.
The case status report shows tagged. I'll give the report. Just give it.
So we will take up your matter on Friday then.
Then your lordship may take up both matters on Friday.
No, we are not inclined to interfere here, Mr. Chidambaram. We may, it may be that your fate of your case will also be the same. We are not sure about that.
They only need to argue the matter. I only want to argue the matter.
Your Lordship, the matter may be taken up on Friday. We are yet to be served with the SLP in item 26.
Why you are unnecessarily making a request with? Why can't you take your seat?
So as far as my matter is concerned, your lordships are not interfering. Will not kindly leave it open, despite without an amendment application. There is a full amendment carried out. We should have a right to object by that amendment which has been filed.
Question of law is kept.
Item 61, we have heard from senior counsels for the as well as Mr. Jalan, who is on caveat on behalf of the respondent.
And I said that, sir.
Keeping the facts and circumstances of the case, we are not inclined to interfere with the impugned order dated 6th February 2026. The special petition is accordingly declined. However, question of law is kept open.
My lord, as far as 26 is concerned.
Just a minute, 26.
Yes.
Counsel for the petitioner as well as Mr. Jalan and counsel for the respondent on caveat. Having regard to the particular facts and circumstances of this case, being set aside, the impugned order dated 6th March 2026 passed by the High Court and grant. How much time you need to file?
My lord, there are two things. My lord, there is not even an application filed for amended petition. My lord, the entire petition has been transformed, restructured. My lord, my 45 days limitation period. My lord,
how much time you want to file an amended written statement?
No, my lord, they need to scrutinize whether that amended petition can be taken.
Your petition,
Yes,
in your amended written statement, please indicate that these have been incorporated by way of an amendment. Therefore, we are raising a point of limitation on these parts of the causes.
These are very good.
My lord, allow us like this. My lord, allow us to file objections to the very amended petition.
We have already
filed the application, my lord.
We have filed objections to the fact that you have amended without
Your
an
lordship,
application.
the objections will be decided by the court.
Statement which is said to have already been filed.
No, my lord.
Lord, we have filed objections to the amended petition which is being done without even an application for amendment. We have protested against that procedure.
No, that you are not permitting the election petition to.
No, my lord.
We are not inclined to entertain those.
How can anybody?
You can raise all those objections in your amended written statement.
My lord, this honorable court.
Look there, first election petition amended. First election petition was 130.
No, please, then we will direct to take. No, please don't compel us to direct to take up this election petition on day-to-day basis. That means you are unnecessarily stalling this. Create a lot of doubt in our mind. Why you are afraid of 1030, 133 votes difference? This young lady is fighting election.
My lord, they are just raising technical objections after technical objections. Your lordship, the High Court has considered this honorable court's judgment and thereafter passed its own order. In item 26, your lordship,
returned candidate is permitted to file amended written statement, raising all the objections where based whereupon the High Court shall formulate preliminary objections as well as preliminary issues as well as issues on merits and will proceed in accordance with law.
My lord, there is one more thing.
So we have permitted you to raise all those things.
I know. Your
Lordship, may I clarify?
Lordship has said in all objections, including the factum of an unauthorized amendment.
Objections which including those which are sought to be raised by way of a separate application.
Yeah.
Your Lordship, may I clarify? I am only on caveat in item 61. I have not been served a copy of item 26
You need not,
SLP.
because we have dismissed that SLP, madam.
Yes. Yes, I just wanted to clarify that the order may not note that I'm.
All right, thank you very much. We have dismissed that SLP.
My lord, just one liberty, that all the rules of the High Court, specifically pertaining to election petitions, may be adhered to, my lord, because discovery, admissions, my lord, all those are also being given a go by. My lord, let the rules be complied with, at least adhered to, my lord.
Nothing now to 24 election petitions should have been decided.
Your Lordship, a direction may be given for time-bound disposal.
Thank you very much.
Grateful.
My matter will be listed.
Your matter will come on Friday.
Very well. There are two
And
other.
Mr. Chidambaram, the question of law in 61, we have kept it open, so you might.
There are two other points.
That is why we are saying you can argue your case independently.
I can argue on Friday. The other point is Mr. Rohatgi's case. He argued only one point.
On this point, in any case, we will not entertain.
Yes.
There are two other points.
Absolutely.
May I please, my lordships? Is a matter in respect of continuation of delay of 765 days without any basic reason at all. Will lordship may kindly permit me to take up the affidavit, page number 267. The only reason stated is in paragraph 4. That the successor was holding the charge as an additional charge along with the regular charge of investigation units. He had to attend various searches, prepare cases for searches along with the charge of benami prohibition unit. Subsequently, the then incumbent was transferred out of the investigation wing.
Notes for your next book.
Stay, my lords. Sure. Stay, my lords. Stay, my lords.
Because we had an interim order throughout.
We had an interim order throughout till then.
Oh, they should pass an attachment order. That's it's a.
Stay of the appeal, my lords. We had an interim order throughout. My lords, your lordships may see at the High Court, my lords. We had an interim order annexure.
It will not be.
P14.
It will not be heard in the meantime.
It may be heard, my lords. P14. We are only saying, please give the same order.
You serve them the
P.
It is posted on 25/6. That's why 25th, my lord.
P15 of your lordships will have, my lords, at page 3.
Throughout, we had the interim order.
Just after 10 days or so.
Interim order till then, my lord.
We put to serve the Item 28.
Yes, oblige. Oblige, my lord.
Question of law. Because why verification or interplay between section 15 and 29A of the Arbitration Act. So this is a statutory arbitration where the arbitrator is always the statutory authority, but this would apply to other arbitrations also, my lord. I'll just point out. Please have a look at section 15.
29A.
First 15, my lords.
15, they have not given up. They gave up section 15.
No, but the court's finding is contrary to 15. Therefore, I want to.
15, definitely. You are absolutely right, Mr. Ray. Because 15 will not be covered, the Maharashtra legislation, section 9, I think, section 19B will definitely eclipse 15.
Correct.
The problem is 29A, because the power to extend now no longer is with the arbitrator.
Correct.
Or with the authority appointing, it is with the court. Will that section be eclipsed by 19B?
My lord, 15 also empowers the court only.
Correct.
No, there is one judgment, I could not lay my hands on this, but please, my lord, for my satisfaction, have 15 first, my lord. Section 15 first, my lords. Termination of mandate and substitution. There is one judgment, there is Friday, there is one judgment on Lord, can I request, my lord, before I proceed? There is one judgment, my lord, that's my impression, I could not lay my hands on. Lord, it's possibly a High Court judgment, not your Lordship's judgment. But there, my lord, there is something, because section 15 and 29A, these are the two provisions only which talks of substitution of the arbitration. 15 says that substitution would be as per the original scheme of appointment.
That is not there in 29A.
My lord, but the High Court therefore says, my lord, according to us wrongly, that therefore I can do anything. So even in case of a statutory arbitration of a particular authority, for example, my lord, arbitration under the Small and Medium Enterprises Act, it goes before a particular arbitral authority, my lord, statutory arbitration. But if it is 29A, then, my lord, anyone can be appointed. He may be a statutory authority, he may not be a statutory authority. Then, my lord, 15 and 29A cannot be reconciled and read together. It's not.
You want us to read in the restriction in section 15 as
in
into
29A. I'm great.
That is your
29A. And ultimately, the High Court says that, but I am not the correct court, and therefore.
That is another.
29A6.
6. And 15.
इसमें sir ये नहीं है.
Or the statute, as the case.
Contract or statute,
Yes,
based statutory arbitration. You are saying that restriction should also be read into section
29A 6.
Current. 15 is given up, only 29A remains. Now, I have one more submission after the solicitor.
My impression is that it covers. I could not lay my hand.
I have something different apart from the act. But I don't think this is the case where your lordship should interfere at all. I'll tell you the reason why. Just note 3 dates, my lord. The award is of 2019. 19. We invoked arbitration for announcement, like Section 18 of the LA Act. Because pleadings were completed in 2021. Mandate of 29 is 12 months. Because the first arbitrator said, I am not granting an award. They changed it.
I am on question of law.
Keep it open. This is not a case of a question of law. 7 years I am struggling. So, my lord,
Is a pan-India problem arising under the National Highway Act also under
your lordships have rendered an order.
Small and medium
Your lordships have rendered an order.
So kindly have it on Friday, my lord. I have some. MSME. MSME, I'm sorry.
Your lordships have rendered an order. Don't have these officers. This is what is going on.
That order was passed under the National Highway.
I've got that, my lord. This is similar. This is State Act, that is Central Act. Now, my lord, I just want to take half a minute more to say that keep the question of.
I'll come.
I have something. One thing. Keep it open, but not with this case, my lord. 3 times they have appointed arbitrator. 3 times they have changed.
Why don't you? All right. Why don't you do one thing?
Yes.
Arbitrator has to be appointed.
Yes, ma'am.
Whether you appoint under the rules.
The High Court has appointed, my lord, 2 retired judges. Already,
Only a minute.
they have started. They have entered. 1 second, please.
Let me answer.
We are only saying we are only trying.
Yes.
We are not to have a point. The statute prescribes an authority who will be then arbitrator.
But you lose your power according to me. You can't appoint now after 5 years.
Statute might be prescribing that who the authority who will appoint the arbitrator.
Mr. Solicitor, we are on facts. Let us say again, we put it back to the Deputy Commissioner Nasik. They have not done it for 1 year. Then there must be an undertaking.
They have failed to perform for 1 year, 2 years, 3 years, 5 years. How long can I wait? 3 arbitrators were appointed. They reserved. All 3 were changed. What should I do, my lord? From 19, we are in 26. They have yet to start a Section 18 kind of a.
Wrong fact cannot lay down a wrong law. I am on law. This is
Law-
not a very
law is
basic
always on
fundamental
fact.
argument.
There is no law
7
in
years
that.
I am suffering this, that. But
What do you mean this, that? This is court
the
is
law
concerned about
comes
submitting
down,
of people.
sections are interpreted, provisions are.
I am very
construed.
sorry. This is not a case for Article 136, my lord. Would your lordship consider that? From 19, we are in 26 today, my lord. 3 times they have appointed arbitrators and 3 times they have changed them. What should a
Time-bound arbitration, but
No,
this law cannot.
who are the earlier arbitrators?
divisional commissioners?
These bureaucrats will never work.
Divisional
We will
commissioners.
strike down these provisions. We are waiting for it. What kind of adjudication they will do? And what kind of
There
judicial
are
might they can apply?
statutes where this kind of arbitrations, but my lord, that may not decide interpretation of 15 and 29. I am only on that.
I am saying leave it open, my lord. Don't
That's
decide.
why we are saying
This is not a case of that
in
nature.
order to avoid any kind of thing, why don't you suggest some names?
Shouting always.
I am not shouting, sir.
At least let me.
I am giving my position. You say facts don't matter. I say facts matter the
The
most.
arbitration is to take place where? This place is which place?
Nashik.
Nasik.
Thane.
Bombay.
Bombay.
Thane.
They have already appointed Justice Qureshi and Justice Dhanuka.
Well, I would like to argue, my lord. I can't, my lord, argue on this such preliminary 7 years and pleading and not paying, etc. This is a question of law decided by the High Court. I may succeed, I may lose. But my lord, it's a 60-page reasoned judgment. Question of law being kept open doesn't help anyone.
Every time this court does it. It's already done, my lord, in one more case of similar nature by Justice Padiwala's bench.
No, these bureaucrats, they will never work because unfortunately they have this the last priority. We have to really intervene. I think the matter will require judicial intervention. People are facing a lot of harassment.
We are facing harassment. We are not getting.
My lord, and in mind that suppose there is an arbitration clause between me and him. Forget the statutory arbitration, which provides for a particular way of appointment of an arbitrator. Would that contract be excluded if it is 29A? That is the question. Forget.
No, the question will be larger, Mr. Solicitor. The question will be that where the civil rights of the parties are required to be adjudicated.
Yes, my lord.
Should that power be allowed to be exercised unbridled, unguided, and absolutely out of control by a set of bureaucrats who are not independent and autonomous authorities? Why they should be permitted to?
I am not on that, my lord. Your lordship may kindly.
That is the only point involved.
While interpreting.
And these are the glaring examples where the statute has failed. These are the glaring example where the statute has failed.
It has failed, my lord, for more than one reason, my lord. I may not go into that. But, my lord, kindly consider non-statutory arbitration between Mr. A and Mr. B, which provides for a particular method of appointment or replacement of an arbitration. That is 29A absolve or nullify that contract.
That authorities are expected to act promptly, they are expected to act fairly, they are expected to act independently, they are expected to act impartially. When they have failed all principles of natural justice, why the court should uphold this kind of action?
Your lordships may perhaps decide this question, my lord, in a better.
We decide. We are ready to decide right now.
No.
You appears to be absolutely correct.
If your lordships, my lord, are my lord, not for the time being consider statutory arbitration. Consider a normal arbitration and interpret 15 read with 29.
No. We are examining the action of a public authority. It is not a mere private contract between two private entities. It is a question of inaction of a public authority.
Lord, this judgment applies to private individuals as well, equally. Your lordships may set aside this provision. I have no difficulty. Lord, this statute.
Monday will examine.
But Lord, these are wider ramifications. I am not only on.
If these are there, please better you introduce a judicial mechanism.
Statutory arbitration.
No. Please tell us what is the problem. Why can't a district judge be the statutory arbitrator here? Why can't be there after the appeal can go to the High Court? Why this kind of circuitous method of depriving the people from judicial adjudication?
Lord, section 19 is ultra virus. Please proceed on that. A question of law will have to be decided, my lords. That's the problem.
Lord, can I just take one more minute?
You see, under one statute, you acquire the land, people have right to go to the reference court. They have right to go to the appeal before the High Court. They can come here also. You can also be aggrieved. You can also go to the judicial court. There is a statute.
My lord, for the time being, for adjudicating 15 and 29A. 19, my lord, all such provisions, my lord, I will take it that are ultra virus. I'll still, my lord, be able to satisfy your lordship that the interpretation is wrong.
My lord, can I just take 2 more minutes? The third arbitrator they appointed said, I have too much work, I can't do arbitration. The third arbitrator they appointed.
Good, my lord. 3 years don't say that, and they don't do work on the lighter side.
I am reading from the order. The third arbitrator in para 7. I am only saying it is recorded by the judge that the third arbitrator on 29th May wrote to the government he will be unable to conduct arbitration
Right.
of the responsibility
we have to
assigned
go
to him,
on such
and he has
preliminary,
listed his responsibility.
on such preliminary points, it is appealed to my lord the Chief Justice. But possibly the interpretation, my lord, will not be able to do it correctly. So these are the best points they have argued. Now let me argue on interpretation.
What do you mean best point?
On interpretation of law.
I am saying, Lord, very simply, 29A is the provision which says if 12 months pass after completion of pleadings, then Lord, it goes to the court. Here, 12 months have passed. 36 months have passed. 3 arbitrators have come and gone. A party can't be remedialist under their diktat that we'll have 1 divisional commissioner, 2nd divisional commissioner, 3rd says I have no time. What else will happen, my lord, in a case of this nature?
And this is how, my lord, would we decide the interplay between.
Again, my lord, my friend is on this, that, or the other.
One
But
third,
this is not a case.
time, not
What is the date when we have listed it?
Law, my lord,
National
we
idea.
have to argue on law.
Let it be another day, not in this case. There is already a judgment of this court in Perkins, my lord, your lordship said. There, the authority appointing would be, my lord, the managing director of the opposite side. This court has struck down those provisions. Say you can't have impartiality.
That is a difference.
Justice Lalit. That judgment.
That is core, not Perkins.
This Perkins.
Somebody has wrongly fitted to Perkins. It is a core.
Core.
Perkins has followed. I'll show you. Perkins is also the same thing.
So that NS matter probably. Like on Friday.
Right.
For Monday, the lordship website. If it is Friday is avoided, otherwise it will be here. If Friday can be avoided, if it can be kept on.
So then there are other matters. Then all right, we will take up those matters also on Monday. Next Monday, Mr.
Please, sir.
Okay. Item 29.
May it please, my lords. My lords, this is a petition under section 11 of the Arbitration and Conciliation Act. My lords, the petitioner is a company established in India and respondent number 1 and 2 are companies based in most obliged.
The expedition. Yes, yes. Well, 38 years we have spent in this litigation. We have 38 years, my lord, we have already
So
spent.
that's right, RSS of 2009 is not a strange thing.
2009 RSA, my lord, we are in 2026.
No, but are you aware in that High Court, the RSS of which year are pending? RSS of 90s must be pending. Unfortunately.
My lord, the original plaintiff has passed away, defendant has gone. The second generation is also in their 70s. All that three applications requesting the court for listing the matter have. All we are saying is, my lord, your lordship, leave it to the convenience of the court, but some nudge from your lordship will help us, my lord.
The petition showed grievance in the instant repetition is that regular.
And we have yet to, my lord, come to your lordship's court once a decision is taken by the High Court. So another long period is anticipated.
From last 15 years. And she is awaiting adjudication thereof. In our considered view, instead of moving this repetition, the petitioner may file a comprehensive application before the High Court, making out a case for out-of-turn hearing of the above mentioned regular second appeal. We have no reason to doubt that the High Court shall consider such application sympathetically with an endeavor to decide the appeal at the earliest. You take this order, it will help.
Grateful.
31, my lord,
is the
Civil appeal, my lords. It's a statutory remedy, my lords, first forum before this court. Well, the niche question which arises, my lords, is whether, my lords, mere uploading section 16 of the NGT Act says, my lords, that limitation period for filing the application challenging the forest claim. This is, my lords, initiated as a pro bono measure, my lords, by an environmentalist. Will commence from the date it is communicated to him, my lords. I'll read that section, my lord. Now, my lord, the
point is already decided.
My lords, I'll answer that.
Lord, he has
Now, my
filed
lord,
an OA,
just a minute, my
which
lords,
is pending.
I am projecting
This
the
was
question.
appeal which is rejected because it is time barred.
This
Now
is
he has
the
filed one
forest
more
clearance.
PIL
My lord,
before
this is the forest clearance.
32.
My lords, that's something that's on 64. I'll argue that separately. I am here. My lords, I am raising a question.
OA is pending.
My lords, OA is different, my lords. OA is, my lords, OA is relating to identification of area as the elephant corridor. That's a misstatement. This was specifically, my lords, I initially filed a combined application before the NGT that notify, admittedly, it's an elephant corridor. It's not a matter of dispute.
Not at all. Not
Notify. I'll point
10
that
kilometers
from
away.
their application, it is mentioned in, my lords.
If you ask the NGT to decide on merit.
OA can be decided.
Not OA, my lords, OA nothing to do. FC clearance.
EC, environmental clearance, the forest clearance is barred by limitation. But he can raise all environmental issues there.
No, my lords,
All
OA
environmental
has
issues.
nothing to do with this forest clearance.
There are two things. Either we permit him to raise all the contention in the OA.
Whatever he wants, Lord, can raise in the OA, provided they are environmentally. Whatever he wants.
Millards, we did that.
But he can't challenge, Lord, which is law requires him to challenge a forest clearance by filing an appeal. That appeal is time barred. Your lordships have held it's a time barred. But destruction of forest, whatever you want to raise everything in OA.
Millards, OA, please see the NGT order.
Now, Lord, just see the approach. Approach is PIL here. High Court another matter
situation, my lords. It's a catch-22 situation, my lords. My lords, may just see one order, my lords. Please see one order.
We can condone this delay and ask the tribunal to decide the appeal.
Yes, no, let him raise it in the OA, Lord. Let him raise all this in the OA.
No, it can't be raised.
Technical issues in the OA, he is not able to
Lord, today, Lord, admittedly it's time barred. That's what your lordship
judgment
judgment
just
have
see
read.
one order, my lords. Please see one order of the NGT, my lords. My lords, before the NGT, they say they take an objection that
OA, he has
OA is
already
not
raised
going to
everything.
go in appeal.
OA, he has raised everything.
Please see, my lord. This is just playing fast and loose with the court. Allow me to show one order, my lords. Please allow me to show one order, my lords. I filed a combined, my lords, combined application before the NGT. NGT says that no, this is not maintainable. File a separate appeal. Please come to one document, page 3. P19, my lords, page 30.
All environmental issues may be allowed to be raised in the way.
This is
He can raise everything.
It's a David versus Goliath fight, my lords. He's for the beneficiary. I'm for the environmentalist, my lords. He has to allow me to say. I am raising a very,
Environmentalist
very
is doubtful.
serious-
Several petitions.
It's a very, very serious issue. An elephant corridor has been bartered away for a coal block commercial entity. my
Lord,
lord.
elephant
It's
corridor is
bartered
10 kilometers away. It says that.
I'm sorry to say.
58
The
kilometers
ministry,
is
the ministry notified as a no-go area. Ministry notified as a no-go area. That
Not
no
at
coal block will be allotted. It is allotted to a private company. Forget PSU or government. For a private company, it's sold off. And nobody knows what is the end purpose of that coal. It is to be sold in the market. And allow me to read one side.
Purpose of the coal is
Well, let's may first come to the
power
NGT order, my lords. I can't be, it can't happen that both my legs are cut, my lords, and I be expected to run the marathon, my lords. Please come to page 309, my lords. What the NGT did with me. Please come to para 309, my lords. I filed OA itself. Yes. And then dismiss my appeal.
Lord, he was given opportunity that will convert it, but he says, no, I'll file different. That's right. That's right. That's the whole joke.
To let appeal be also decided along with that.
Lord, appeal your lordship may not delegate, but OA permit him to raise.
I am opposing that, my lords. Otherwise, my lords, I'll be back.
Lord,
to
appeal
that-
is time barred. Appeal is time barred. In OA he can. OA.
My lords, I allow me to explain why I filed a joint application, my lords. Please, my lords.
Allow
I
my
filed a
lords to
joint
speak.
application saying, my lords, that if I filed a joint application saying that if this area is notified as an elephant corridor, in view of my lord's judgment in Binay Dalai, no mining activity can be carried there. And therefore, forest clearance permission is a bogus permission because the Ministry of Environment and Forest has recommended that area to be notified as ESZ. It is not notified for the, I'll show that document. It is not notified for the failure of the MOEF. Then, my lords, very same ministry grants forest clearance for this coal block, my lords.
Write down. The instant appeal is directed against the order dated 22nd April 2026, passed by the National Green Tribunal Principal Bench, New Delhi, whereby a statutory appeal preferred by the appellant under section 16 in bracket small e of the National Green Tribunals Act 2010 has been dismissed on account of delay of 259 days in filing that appeal. Counsel, we have heard one counsel for the appellant as well as one senior counsel for the report is number 7, who is on caveat. It is true that the appeal filed by the appellant was time barred, and on facts the view taken by the NGT seems to be correct. However, it is a matter of record that OA number
OA number 116.
of 2026. No.
OA is 116.
Lord, OA is 116 of 2026.
Appeal is,
Which is pending?
appeal is 14.
OA.
OA is pending. Which OA is pending right?
My OA is pending.
Yes.
Number
116. 116 of 2026, page 309.
OA number 116 of 2026 filed by the appellant is pending before the NGT, and both the issues raised in both the.
Please come to page 310.
Yes, my
I
lords.
do not think OA 116 is pending.
No, it's pending, my lords.
Please, sir, read
Yes,
paragraph 5.
My lords, what the tribunal did is, it said,
Can we request you to read paragraph 5?
yes, I am sorry. May I read then 4 also?
Exactly.
Thus, applicant is required to avail the appeal in terms of clause 16E of the NGT Act against the impugned approval for diversion of the forest land. For other issues, he has a remedy for filing the OA separately. If the need so arises, both OA can be heard together. Then, therefore, it is open to the applicant to convert this OA in appeal by confining it to prayer alone, wherein challenge to the approval for diversion has been raised, and file a separate OA for other reliefs confined, or file a separate appeal for prayer clauses. So what I did is, I deleted these relief of forest clearance from the OA. The OA is pending. In the OA, I have requested that this elephant corridor be notified as ESZ.
Eco-sensitive zone.
Yes, under the Environment Protection Act. And number 2, then National Board of Wildlife also notifies it as an elephant corridor.
What you may do is, because your prayer in the OA is that this is an eco-sensitive zone, because it is an elephant corridor, and if you can establish that you are entitled to that relief,
that's pending.
You can, without challenging the forest clearance, ask for an interim relief of not changing or giving effect to the forest clearance order.
My lords, with due respect, I'm grateful that my lords have got my point. My difficulty is tomorrow they'll say that unless and until the statutory forest clearance is set aside, it will hold good. And my difficulty today is, my lords, 70,000 trees in phase 1. They have started the deforestation activity. The writ is filed that they should not go on. Please come to the site inspection report. My lord, deforestation has to stay, my lords. Deforestation has to stay. This forest clearing activity has to stay. Yes, I'm sorry.
Lord, that OA, he can raise all points in that OA, whatever he wants to raise.
Be able to, and in any case, how it will not cause any prejudice to you.
My lords, may I request my lords to read one page, my lord, the seriousness of this matter, my lords. There is a wildlife. 0.6 saal for
wildlife is all blackmailing litigation.
That's right.
Everybody knows it.
That's right.
You are not. Anyway,
but it's an ongoing mine which is going on.
Was time barred, and the view taken by the NGT in this regard is seemingly correct on facts as well as in law. However, it is also not in dispute that OA number 116 of stroke 2026 filed by the appellant in respect of related issues, namely seeking the declaration of the area, seeking a direction to notify the area as eco-sensitive zone, it being allegedly it being an elephant corridor, is already pending. That being so, we are of the view that no serious prejudice shall be caused to number 7 if appeal number 14 stroke 2026 filed by the appellant is also heard along with that original application. Consequently, the instant appeal is allowed in part. The impugned order of the NGT dated 22nd April 26 is set aside, and the delay in filing appeal number 14 stroke 2026 is condoned, subject to the condition that the appellant shall deposit a cost amount of Rs 10,000 with the NGT principal bench
Lord, this will be used as a precedent. So what I would suggest, the same thing.
For the benefit of the NGT Bar Association.
Lord, what I would suggest is this will be then quoted as a Lord precedent, saying that despite this, there's a judgment of your lordships, Lord, saying that it can be condoned.
No, that's different.
Hold the
You
order,
pointed
but
out.
allow Lord him to raise this forest clearance issue in that way.
No, where is the judgment?
Yeah.
I'll
And the NGT has relied on this judgment.
Millards, it is different.
NGT has relied on this
Different.
judgment. The delay can't be condoned.
I have annexed that with my. I have annexed that.
Even under 142, it can be condoned.
Para?
17.
Millards, allow me to distinguish this
17 and
judgment.
18.
I have annexed with my civil
Can't be
appeal
condoned.
also.
17 and 8. There are a series of
It has
judgments.
not considered the 1962 judgment of my lords interpreting what communication means, my lords. And then the facts
17
are
and
also
18 that the
facts,
NGT cannot condone the delay, and there are judgments not under
and
142.
facts are also different, my lords.
So therefore, allow him to raise it in OA.
Facts
Allow him to
are
raise it
also
in OA.
different, my lords. Facts are also different, my lords. May I just
Same
argue?
thing.
They are
What
not allowing me
evidence
to
is
argue.
to him, Lord, if he can raise it in
Millards,
OA.
they are not allowing me to argue, my lords.
In view of the decision of this court, in Kali Gram Panchayat versus Union of India, 2025 SCC online SC 2497, post this appeal before the bench presided over by Honorable Justice P.S. Narasimha Ji on Friday.
Millards, can it
Lord, that writ petition should be dismissed. How is the writ
No,
petition
Millards, writ
maintainable?
petition may go along
Under
because
52. What is
Millards, that's 64, my lord.
Writ
64 is
petition
there.
filed under
Millards, I'll demonstrate, my lord.
We are challenging the
Millards,
project.
I'll demonstrate why writ petition is there.
How
Millards,
is
today, Millards,
in view of the fact that the petitioner has already approached the NGT or has also taken the route of statutory appeal, we are not inclined to entertain.
Millards, allow me, my lords. I can't be left remediless, my lords. Today, if the NGT, Millards, today, if the NGT, Millards, today, if it is held that it is time barred, my lords, there will be no forum where the forest clearance can be challenged.
That appeal, we are listing that appeal.
My lords, what I am saying is, please appreciate, my lords, if my lords dismiss the WP,
To abuse the process
my
of.
lords, I am not abusing, my lords. I can't be remediless, my lords. It's a statutory tribunal, my lords. Then no, my lords, allow me, my lords. My lords have held. There are judgments of this court that allow me, my lords. There are. I wanted to press.
We can observe that the abuse of process of law, it will create problem in appeal also.
My lords, my lords, this is a genuine case, my lords. It relates to, on record, my lords, there is a report which says that coal block is allotted in an elephant corridor. There is a report of the forest department. I have annexed that. Now, my lords, what I am requesting is please consider this, my lords. My lords have in umpteen judgments held that the statutory limitation for a tribunal will not debar the constitutional court from examining any issue. If today, my lords, NGT issue is held against me that is time bar, I'd be completely remediless, my lords. Delay this limitation cannot held. That's why I'm saying, my lords, writ petition may be kept pending, may go along with the civil appeal. My lords may give me liberty to raise it before the appropriate forum. Otherwise, I'll be remediless, my lords. My lords, the seriousness is, please appreciate. If tomorrow it is held that NGT's view is correct that it was time barred, please appreciate. Then my NGT application is dismissed.
Thank you. Item 33.
My lords, my NGT application is dismissed. I am remediless is my submission, my lords.
You are not remediless. Your appeal will be heard by Justice Narasimha's bench.
My lords, but that's what I'm saying. If the
Hear your appeal. That's why.
if the court takes a view, my lords, with due respect, that it is time barred, then I am nowhere. I am remediless, my lords.
That's you want to continue with one or the other blackmailing.
No, my lords, it's not. It's a report. I am just requesting that the report which should be taken into consideration.
So you want us to lay down a principle that even if the appeals are time barred, we should entertain 30.
No, my lords, there is a settled law that if time, my lords, I am just answering my lord's query. Settled law that if there is a time bar for a tribunal, that will not debar the constitutional court from exercising jurisdiction. Delay and latches is the principle.
We will examine that part.
Lords, may I make a request? My lords may not dismiss the writ petition. My lords may just link it. My lords may not issue notice.
Sorry, dismiss, or at the best you can withdraw it. That's all.
My lords, withdraw with liberty to agitate if needed, my lords. At least that may be done.
Question of any liberty.
My lords, I'll withdraw it then, my lords. My lords, may I make a request?
Timeline counsel for the petition, seek and permitted to withdraw this writ.
My lords, may I make a request? Can it be next Monday? Can it be next Monday? My lords have posted on Friday. Can it be next Monday? My lords have posted that on Friday.
When do you want?
Next Monday.
Next
Friday is my sister's marriage.
Next Monday.
Grateful.
No issue.
Grateful.
Please, your lordship.
Your Lordship, this is a big online fraud that happened, and unfortunately, my foundation's account, some money was routed through my foundation's account.
Question of stopping from coercive action.
Your Lordship, as on today, 2 months I have gone to jail. All the police officers from various states are behind me. They're coming to my residence. They are in court, Your Lordship.
How much amount has come to your account?
Only 10 lakhs in this FIR.
Only 10 lakh.
Out of which 9 lakhs has already been given to the complainant by way of a
And
supervisor.
how many other people have been duped?
Your Lordship, this is a big fraud, and I myself am a victim to the fraud. In Feb 2025.
That may be true, but that's a matter of investigation.
Very well, Your Lordship, but there are multiple state authorities that are behind me. Which forum should I approach to get anticipatory bail, Your Lordship? I'm in a very difficult situation currently. I'm a physiotherapist, Your Lordship. This is a charitable foundation. My only bad luck was that some amount got routed through.
You have done well physiotherapy of how many people throughout the country?
Your Lordship, the details of our bank account, because of donations, was available on the website. Our website had the details of our bank account.
These are all question of fact. There are serious allegations against you of duping people on pan-India basis. Better the investigation is conducted, but in any case, whatever defense you have, the investigating agency will examine it.
Your Lordship, it's not a question of defense. In fact, my only worry is, Your Lordship, because I am going to get picked up in all the other FIRs, which is from the same cause of action, Your Lordship. The cause of action is the same online fraud.
There is nothing like cause of action same. If you have duped 10 people in the same modus operandi, that does not mean that only one offense you have committed. You have committed 10 offenses then.
Your Lordship, I'm relying on Your Lordship's judgment. Your Lordship, I'm relying on Your Lordship's judgment in State versus Khimji, Your Lordship. In this case also, the other FIRs were treated as 161 statements, Your Lordship. So there was only one primary FIR.
All right, shows where the mistake I have committed.
Yes, Your
Which
Lordship.
judgment are you referring to?
Your Lordship, State versus Khimji by Jadeja, Your Lordship. The judgment of this Honorable Court, Your Lordship. Your Lordship, para 20 of the judgment.
Where are the facts except that citing judgments and judgment? Where are the
Your Lordship, in this case also, Your Lordship may come to the initial paragraphs, Your Lordship. This reference was raised by the Sessions Court to the High Court. The Honorable Sessions Court had made a reference to the High Court, Your Lordship. And in this case also, 1,800 complaints were filed, other than the first FIR.
This case has nothing to do with your issue, madam.
Your Lordship, only on this point I'm relying on, that this be the primary FIR. All I
No, no,
seek is,
this is absolutely irrelevant.
all I seek is interim protection. I'm a 44-year-old man. I'm a physiotherapist. I'm running this charitable organization. Day in and day out, state authorities are at my residence, Your Lordship.
To entertain this petition without dismissal.
Your Lordship, I may be allowed to withdraw the petition in that case.
All right. After dragging the case for some time, non-consent for the petitioner seeks permitted to withdraw this. Matters को लगा देते. Yes, item 34.
Yeah, please, my lords. This is a similar case, my lords, in which 11 NCRP complaints of cyber crime.
Banks को लूटा है.
Yes, my lord. My lords, he was just a mere employee, office boy. He was made a director. He was not even aware what all transpired behind his back. We've annexed his bank accounts also.
Can't entertain this.
My lords, at least some time may be granted for us to go and approach.
No, nothing.
Oblige, my lords.
35 needs to be grouped with order at page 85.
88, same order.
ये बोला ना?
We proceed, but
So,
issue not. This is fresh.
Issue not to track.
And will stay on the court.
Same.
Great.
Lord, your lordship granted me indulgence. I went back before the Honorable High Court, my lord. Unfortunately, couldn't get heard fully, my lord. Only submission. One submission, my lord. One only submission. My lord, there is page 47, only one paragraph. The reasoned order passed by the competent authority Y17A was not granted. Only one paragraph. Page 47. Totally unblemished record, my lord, and please see 47, one paragraph.
That's right, but simple adjournment cases we are.
No, not adjournment. I am, my lord, my term of MD, which, my lord, I am today 56 years of age.
That is there on 15th May advance list.
No, I am saying something else, my lord. I am giving a very respectful suggestion. Kindly consider it. I am 56 years of age. I am entitled to be considered and continued 5 years, 3 years, 2 years for a period of 10 years. My term by the central government, my lord, approved for MD 3 years in 23, which is coming to an end on 31st of May this year, now this month. My lord, I go home if I don't get my extension. Let the government consider divorce this case my extension with 47, page 47. My lord, only one paragraph at 47, which my lord conclusively says that I have no role to play of the allegation.
Not everyone will.
Just at page 147, my lord, only one paragraph.
You believe these bankers, it will be something.
My lord, kindly see page 47, my lord, the competent authorities observation. Just have a look at it. I'll just read it. Don't open it, my lord. It is noted that during the tenure of petitioner.
The matter is coming for hearing before the High Court on 15th May 2026. We see no reason to entertain this facility.
Would your lordship make an observation? This prayer be considered on that?
No, that will be very embarrassing for the High Court.
No, my lord, I follow, my lord. But what I'm, my lord, 31st of May.
It becomes, you please appreciate, it becomes very difficult.
My lord, I am only your lordship consider, my lord. My consideration would be subject to for your lordship.
That matter is coming on 15th. You produce this order, it will help you.
Very well, my lord. Otherwise, my lord, I would come back to your lordship with this prayer. My lord, my case be considered before 31st of May, subject to your lordship's orders further.
No, this is what the government.
Anyway, so my lord, I'll go. Then your lordship may permit me to go back, my lord. Your lordship may say, I'll pursue this case on 15 when the case comes.
We have said so.
Very well. Very well.
Liberty to proceed the matter before the High Court. Yes, item 62. The status report.
Yes, Danny. Yes, permission.
Compliance report is taken. The compliance report filed by the Registrar General of Odisha High Court is taken on report. It is our clarified that the observations made in the order dated 4th May 2026 shall not be taken as an aspersion or adverse comments against any learned judge of the High Court or a member of the district judiciary.
I'm appearing for the state of Odisha, my lord.
Manoj, it has been, the compliance has been done, my lord. I am appearing for the High Court of Odisha, my lord. Compliance has been done, my lord.
Compliance is taken as report. You are for the state.
So the state.
Mark Medicine presence.
Divya Roy.
I just only added one line that it should not be taken as a personal, because sometimes it can have very demoralizing effect.
Yes, my lord. Yes.
63 and 63.1 ये रजिस्ट्री इतनी इनकोरिजिबल है, मैंने कहा था सेपरेट नंबर पे लगो इनके. Why can't they list 63 and 60?
Just hold on. Toilet? Which one is called?
It was reported in that video clip, but immediately I got a report from the Chief Justice that oral observation was made, which was never made part of the judicial order.
I know that, Lord. Ultimately, he didn't go to jail also. I know that. I have something else to say, Lord. Today, this is a high time your lordships can consider that there should be some internal in-house. I don't want, Lord.
That we are doing.
So that, we encourage the younger bar. Instead of discouraging the younger bar.
So that passing a detailed order.
Yes, so that your lordship will have.
One is about the internal mechanism. Secondly, we are also sensitizing the judiciary at every level how to encourage the young members of the bar.
That's
very, very important because they are.
And also, Lord, certain behavior. So, for instance, I'll tell you, Lordship, if you are arguing something, as a bar leader, I can say anything. But when I'm representing a client, I'm always conscious that if I say something extra, my client should not suffer. So, if the court says, no, if you say one word, I'll impose cost. Now, that is something which is not, ultimately cost will be paid by the client.
We are also inclined to bring few lines for the initiative the Supreme Court bar has taken. Because we want the other bars also to be encouraged like
absolutely,
that.
Absolutely. Bar also should actually stand up for the profession rather than not just.
Very true. The instant petitions have been entertained on the basis of communications addressed to this court by the Supreme Court Bar Association as well as the Bar Council of India in relation to an incident stated to have occurred in the Andhra Pradesh High Court on 6th May 2026. A video recording was widely circulated on social media that attracted considerable public attention. The incident pertains to an exchange between a learned judge of the Andhra Pradesh High Court and a young member of the bar, during the course of which the learned judge allegedly expressed displeasure over the latter's perceived lack of diligence in the conduct of proceedings. The learned judge thereafter is said to have proceeded to dictate an order directing that the young counsel be taken into judicial custody for a period of 24 hours as a measure of punishment for his conduct. Pursuant thereto, it was alleged that police personnel were summoned to the courtroom and directed to escort the young counsel to the Registrar Judicial of the High Court. It is in this backdrop that communications addressed to this court seek appropriate action in respect of the incident. Next paragraph. Having received, even before receipt of the formal communications from the SCBA and the Bar Council of India, from the Chief Justice of India, deemed it appropriate to obtain a report from Honorable Chief Justice of the AP High Court, and in reference thereto, a communication dated 6th May 2026 has been received. The communication reveals that the incident originated from a disagreement between the learned judge and the young counsel regarding a judicial precedent applicable to the matter under consideration. The situation was escalated when the learned judge formed an impression that the young counsel, in a state of frustration, had deliberately struck his file against the podium, whereas the young counsel kept on explaining that the file had inadvertently slipped from his hands. The report of the learned Chief Justice further revealed that the verbal exchange that ensued was recorded by an unidentified individual who then circulated it on social media. Next paragraph. Honorable Chief Justice of the High Court has observed that the video clip in circulation is truncated and largely bereft of context capturing only a limited portion of the proceedings. It has been indicated that the issues to be resolved between the concerned parties prior to the clip containing, prior to the clip being circulated on social media. The report record that the Honorable Chief Justice interacted with the young counsel to affirm that the misunderstanding had been amicably resolved and no complaint whatsoever was lodged before the Bar Council or any other forum. In fact, the Andhra Pradesh High Court Advocates Association also addressed to the Chief Justice of their High Court, informing that the matter stood amicably settled with their intervention. Next paragraph. The positive, the most important and positive contents of the report of the learned Chief Justice reveals that the young counsel expressed that he harbors no apprehension or fear in continuing his professional duties. A similar interaction was held separately with the learned judge also. Next paragraph. Taking note of the situation, the Honorable Chief Justice of the Andhra Pradesh High Court has constituted a committee of 5 judges to foster and maintain cordial bar-bench relations. In addition, a separate grievance redressal committee comprising judges, learned Advocate General Andhra Pradesh, President of the High Court Advocates Association, and representatives of the Andhra Pradesh Bar Council has also been constituted. Next paragraph. It may thus be seen that two divergent versions have emerged. One emanating from media reports and the other from the self-speaking report sent by the Chief Justice of the High Court. From the material placed before us, it appears that the learned judge, whom in the course of proceedings sought to draw the attention of the young counsel to a reported decision which was supporting his case, where the young counsel insisted on placing reliance on another precedent which the learned judge thought was inapplicable to the facts of the case in hand. It further appears that in the course of exchange, the case file of the young counsel held to the ground, an occurrence which was not attended by any deliberate intent. The learned judge, however, appears to have construed the same as an act of impropriety, leading to certain strong oral observations which were eventually not incorporated in the judicial order, and consequently no occasion arose to issue any executable direction. The matter thus stood concluded at that stage. Next paragraph. The report submitted by Chief Justice of the High Court substantially alleged the concern that had arisen. Not only the Bar Association, but the young counsel concerned have accepted the incident in its proper perspective, and he has expressed his determination to pursue the professional responsibilities in a most diligent manner to render effective assistance to the poor. We are thus of the view that the incident in question does not warrant any further action at our end. Next paragraph. At the same time, we consider it appropriate to observe that members of the judiciary at all levels ought to exhibit patience, compassion, and a spirit of encouragement, particularly towards young entrants to the legal profession. The present juncture necessitates that young law graduates emerging from a wide variety of institutions are encouraged to join bar, especially at the level of trial and district courts, so as to imbibe the foundational principles of legal practice. While, next paragraph, while it is certainly the solemn duty of the senior members of the bar to inculcate in young advocates ethical values, discipline, professional commitment, and a habit of continuous learning, the responsibility does not rest with the bar alone. The bench is equally entrusted with the obligation of nurturing a robust and ethical legal profession. That's one that fosters competence, integrity, and a sense of duty, so that every young lawyer is guided to first recognize their role as an officer of the court and thereafter only as a representative of the courts. Next paragraph. The Supreme Court Bar Association has already led by example, and various initiatives have been undertaken in recent times that demonstrate the manner in which young members of the bar are being meaningfully integrated into the noble profession. We expect the Bar Council of India and the state bar councils also to undertake structured orientation programs on a pan-India basis for new entrants to the legal profession. Similar initiatives would be desirable on the part of the High Court Bar Associations and district bar associations across the country to facilitate the smooth induction and professional development of the young members of the bar. Next paragraph. It scarcely needs emphasis that the judiciary must actively collaborate with such initiatives and contribute towards the qualitative enhancement of professional standards within the legal profession. Judiciary must remain mindful of the fact that the strength and caliber of the bench, whether at the level of the district judiciary, the high courts, or this court, are intrinsically dependent upon the continued nurturing and development of the bar at all levels. Next paragraph. We also consider it necessary to make an unequivocal observation that the media has a vital role to play in this regard. The dissemination of decontextualized video clips without presenting the full background in which certain expressions may have been made has the potential to cause unwarranted prejudice to the institutions as well as to the administration of justice. We therefore expect that the media will also play a very proactive role with a heightened sense of responsibility to appreciate the need to discharge their obligation in a manner that is fair, balanced, and conducive to the larger public interest in collaboration with bar and bench. Anything else?
My lord, I want to make one submission, my lord.
Will also have to include, Lord, these YouTube, these social media. These are actually problem more in social media. So there has to be some responsibility on the social media. When it uploads something, they should also have to take some responsibility.
That's why we have requested them that.
No, only the request only, but it should include social media.
Yes, social media, of course.
Actually, this is in the other suggestions that we have given, Lord, for
the rest of the media. Usually, our particularly our legal correspondents, reporters, and even those who are at very high level editors, and they are very responsible.
They are responsible by and large.
The quality of the reporting.
Some in-house so that at least
the amount of public service they are rendering to provide what's happening in the judicial system, in courts, and the amount of public awareness about their rights, their responsibilities.
Actually, the media which is permanently placed here, Lord, they really know how the system functions.
No,
those who are not permanent places, they don't know, Lord, how they, and that's where the misreporting happens. But would your lordships consider, Lord, having some kind of a probably in-house only? Probably in-house, Lord, at your lordships next Chief Justice's conference to have a
appropriate. We deem it appropriate to impress upon all the high courts to constitute the Grievance redressal committee, which must associate representatives of the bar associations and the bar council at the high court level. Such grievance redressal committees should also be constituted at the district and taluka level, with a fair representation from the members of the bar. Also, such an institutionalized mechanism will ensure that the issues that may arise between the members of the bar or the judiciary are amicably, effectively, and timely resolved in a congenial atmosphere.
No, my lord, I would like to make a submission, my lord. My lord, in some of the high courts, even the litigants are not allowed entry. My lord, now some of the high courts, litigants are not even permitted to enter. So, my lord, security is one thing. And my lord, now
we will not be able to make anything.
My lord, now the whole issue, my lord, simple solution is live streaming of court records, live streaming of entire proceedings, and preserve the records. My lord, now
that litigants are not being permitted to be.
My lord, now I can say from my lord, with my lord, from 79 onwards, I've been either a litigant or a lawyer. For 42 years I'm a lawyer, 5 years I'm a litigant. So I know things from the from the perspective of the litigant.
We have.
I don't think that litigants are not being permitted, but
No, they are not.
There, yes, we can address that.
Your lordship will find in Kerala High Court not a single litigant your lordship will find.
In fact, we encourage litigants to watch online.
Yes.
Because the capacity of the court is limited.
Not only
so more and more.
I disagree with my friend, respected friend Vikas Singh. The scenario is to not ask Rosie as my friend would.
We have requested SCBA to look into.
My lord, now as of now, my lord. See, my lord, today, my lord.
Don't tell us.
My lord, the issue is all that I focus is live streaming of the court proceedings. We need to go into the reasons why lawyers are badly treated. So long as the system of designation provide, so long as the collegium system provide, the solutions are not there. So, my lord, we need to address this to find out what is the reason.
Yes.
Then only solution comes. I came a bit late.
There is a delay.
Because I was told the matter will be taken after lunch break only.
Sorry, apologies, madam. There is a delay in the matter, in the filing the appeal.
So, your lordship says something about the litigant.
Sorry,
something about the litigant.
I understand, but okay, I can try because just 2 points I had.
this mining lease was for 20 years initially granted. After the amendment now, it has become 30 years. Now, why this delay happened, can I just indicate? By the time the High Court decided the matter, the 5 years out of those 10 years got over. But now the amendment has come, where it is.
By now made enough marble into granite.
Now the amendment has come where it has become 50 years, that's the reason why. Can I just.
Not entertain. 50 years means let other people should participate in auctions and let public access.
Actually, there is a statute has been amended by the Karnataka binomial concession rules by which 50-year lease has been granted instead of 30 years.
This is how the lies.
I only respect.
Monopoly, they don't allow other new players to come into field.
Actually, because we invest money in it, that's why we get a renewal for 50 years because that time it is granted. My request, my humble submission was that if this period of delay can be cut out from my renewal, Grateful. Lordship may dismiss it on delay.
On the ground of delay.
Grateful. Obliged.
Yes, in this case, kindly see the issue is in regard to the panchayat land. Kindly see, ऐसा धोरीदार is
that matter pending.
Item 37.
Our thing, the main matter, our thing, it will be.
Yes, that is also there. It's listed today. That matter is also listed today.
Those matters we have already issued notice. There are other matters pending. The security issue, I think, is now issue is over.
I am 39.
38 is security.
What is the position in the investigation is complete, and you can't tell who will, Mr.
Actually, Mr. Raju was appearing online.
Mr. Raju has been appearing.
Well, our investigation is going on. We will file a detailed status report on the next date.
You have filed some latest report, Mr. Raju.
No, we have not filed. We want to file it on the next date. We'll file it on the next date.
Is complete. You whatever charge sheet you file it, charge sheet law will take its own course.
Very well, Manoj.
Mr. S.V. Raju, and additional solution, we are presenting the National Investigating Agency state that time be granted to file the first status report. We are, however, of the view that let the National Investigating Agency complete the investigation at the earliest, preferably within a period of 1 month, 2 months, within a period of 2 months, and may submit its investigation report to the Court of Competent Jurisdiction. The law will take its own course. The protection granted to the judicial officers, the civil and police administration of the state are directed to continue to evaluate the exception to the judicial officers and take necessary steps to ensure that the life and liberty of the officers.
But no more filing of status reports, Manoj. No more filing of status reports.
Yes, there is no need. You can now proceed there to file.
Very well.
39, Lord, I am appearing.
Just see whether your lordship could give any direction now. There was security arrangements for the judges, who had gone back to their residences within the state of West Bengal. Those who went outside, there was nothing. The lordship has said on 24th, on 13th of April, that the security given to them is not to be withdrawn without prior permission. Whether this
yes. We have said that now threat perception may be evaluated, and wherever required it will continue. However, if the issue will add however the authorities find that there is no threat perception, then appropriate decision may be in that regard we take action. So item 39 is.
Milord, I am appealing. Milord.
I'm also.
Enumeration of the voters who are still under adjudication and before the applicatory. That should be done in a proper manner.
Milord, I have brought, Milord, I have made a chart. Now, Milord, I will show to your lordships 31 seats. 31 seats. One, Milord, total case deleted under adjudication and loss margin is less than that. Is less than that. And there are cases almost same or 500, 600. These are the cases. Once your lordships have indicated that if this comes in, then your lordships will look into that. If your lordships kindly allow me to, I will just hand over. I will just show to your lord. Just I take your lordships a figure. Kindly see one.
Whatever idea you want to file, you file. We will also get meanwhile some information from.
Mr. Bandhavate.
Milord, I have brought.
Mr. Bandhavate, whatever you want to speak, say about, as you say, with regard to results,
right,
which may have materially affected because of the deletions which are under adjudication, that requires an independent IA to be taken out.
Milord, I will. Of course, Milord, I
will also have a chance to
Please,
know
Milord,
what they have.
yes. Milord, I will show you most interestingly, Milord, I just tell you, lords, 862 vote. My candidate has lost. And this 5,432 vote under adjudication. I will file. I'm just giving an impression.
We can only improve further mechanism for adjudication of the appeals. Rest, whatever is to be done, you are fully aware about.
No, I will do it. But Milord, kindly take one statistics total. Milord, total one statistics. Mr. You will not allow anybody to speak anywhere. Mr. Naidu will never allow to speak anybody. But differences, just differences. 32 lakhs total. 32 lakhs. By the margin, just kindly here. Margin, loss of margin, 32 lakhs. And appeal pending, 35 lakhs.
So therefore, appeals are to be decided in a timely manner.
Now, one of the, Milord, it has come up, and I also had a talk just now. The ex-Chief Justice Sivanganam has resigned.
So what can we do? No, we can't compel a judge to work it.
My lords, there's a sense that it will now take over 4 years to adjudicate.
So that's why we are
7 lakhs.
We are indicating you that we will also find out. It's not that former judges are not readily available.
Even we too have come across news reports.
Time has to be given.
Chairperson of a particular tribunal has resigned on a personal ground.
Time
Could that be a subject matter with your lordships?
Elections in
If they have any grievance, let them put it in writing. We'll look at that one.
Kindly see one thing. Every year election is held either in the corporation municipality or panchayat levels, then the parliament, 3 years. Next year, corporation, then panchayat, then parliament. Therefore, it has to be in our state, kindly Milord, our state,
electoral roll, so far the,
Millards,
our
your
electoral
lordships
roll
have
state
supervised the
follows.
whole process. It has come to an end.
But we have to find out a mechanism for that.
The law is clear on that aspect.
Otherwise, my lord,
Once they have any grievance, their remedy could be election petition as far as the elections are
will
concerned.
hear
If there is
that.
any lapses in SIR, they could as well bring to your lordship's notice. We will answer them.
Why is this
We
ground in
cannot
the election
translate
petition?
everything.
Otherwise,
One
my
should not have to make an issue out of it.
Is there any, no,
One should be grateful.
blood election, no election. Blood, is, kindly, blood, kindly,
The law
otherwise,
can
my lord,
that
blood,
aspect.
excuse me, my lord, kindly excuse me. Pass an order that this will be the ground in the also election petition. This one also be the ground of election petition.
How can we, whatever ground you want?
Therefore, there is no
Lords have
scope.
exercised.
But we indicated to you.
My lord,
Subsequent event, you are at liberty to take out appropriate
my lord.
IA applications. The opposition which Mr. Naidu may have would come as a counter, either to its maintainability or to its factual incorrectness, etc., etc.
This is from-
We will look into it
We are-
and will pass appropriate orders.
One.
With regard to the other very compelling issues of pending appeals,
Yes,
we
yes.
will require to get a report from the Honorable Chief
My lord.
Justice of the High Court and take stock as to how and in what timeline they can be resolved.
My lord,
Right?
fundamental.
Precisely, Millards, that's all we have been looking forward to.
My lords.
This is what we are indicating. Next item 40, please.
Grateful.
Next, my lord, when,
otherwise, my lord,
next, next,
Item 40.
Lordships.
We'll do it.
Giving a date.
my lord. Already, in the meantime, we are filing an application. We are filing an application. My lord,
Grateful, my lord.
deeply obliged.
Item 41.
Yes, your lordship. Yes, your lordship. Your lordship, I have,
We have filed a statement.
submitted a short, brief note, your lordship, regarding the status report
41, sir.
which has been filed by CWC. I have filed.
Take both the mics and.
Yes, your lordship. Your lordship, I have filed a brief note regarding the status report which has been filed by.
Madam Ashwini.
Yes, your lordship, I have already
has
served.
We have also filed a status report, my lords. The DCP
Your
who's
lordship,
taking up the
regarding the-
investigation is also here. So
Yes.
the investigation report has been filed. 4 more weeks, we will complete the investigation. My colleague is probably, my lords, today requesting for orders on
Now,
custody
is
of the
this
two children.
Custody, your lordship.
She is still in the hospital or she has been discharged?
She has been discharged. Now she is in stable condition, your lordship. So far, your lordship, the custody is concerned regarding the two child, your lordship. What we are praying, your lordship. In fact, the CWC has
Madam
also
Ashwini, the
observed.
1-year-old girl child, she
Yes.
go to the mother immediately.
Yes, ma'am.
And so should be the 4-year-old child.
So my lords, we,
Persuade the parents,
grandparents.
the grandparents.
Yes, my lords.
They should hand over to the mother. Mother, she is the natural
It is-
guardian, and particularly in the case of girl children.
Yes, my lords.
Now,
So my lords,
Your
your
lordship,
lordships
the-
have directed
The
us.
babies are with CWC, your lordship, because at page 13, they have said that at your lordship, I have written on 8, your lordship, on 8, there's
what
another
is the status of the
CWC.
investigation?
Well, as investigation is going on, we have given out what all we have completed. 4 more weeks and we will complete it.
Your lordship, on my first page, your lordship, I have submitted, your lordship, that on 8/5, CWC reportedly took custody of the minor child after inquiry revealed that the grandparents were not residing at the village. So they have given a false information, your lordship. So it is now the custody is with the CWC. So what my prayer, it would be at the paramount interest of the child. It can, if it,
Yes, madam.
Have you seen the CWC report?
Yes,
yes,
madam.
your lordship.
My lords, your lordship is so direct for custody, my lords. My lords had asked them to investigate.
And the
if
younger
they are-
baby
if
is
the
looking
grandparents
for
are
the
taking care-
mother, your lordship.
The
Repeatedly
grandparents
asking.
The grandparents appear to be taking care of the children, but now the mother is well, she's discharged. So the
So
children
she can be
look to her, my lords.
able to look after.
What about the investigation going on?
Yes, my lords, investigation is going on. If your lordships will have our status
See,
report.
as per the status report filed by the Delhi Police, investigation in FIR number 176/2026 is still going on. We impress upon the investigating officer to make an endeavor to conclude the investigation and take it to a logical conclusion at the earliest. Next paragraph. As regard to the two minor daughters of the victim, who are 4 years and 1 year old respectively, and are right now in the custody of their grandparents.
Your lordship, it's with CWC, your lordship.
Paternal grandparents. Example, as regard to the custody. It is directed that the custody of both the children be handed over to the mother, especially when now that she has recovered from her injuries and has been discharged from the hospital. The NCT of Delhi is directed to provide all facilities, including the play school, regular school, to the girl children free of cost, and for which all and the entire expenses, including school fee, dress, books, transportation, public transportation, etc., shall be borne by the education department of the NCT of Delhi. NCT of Delhi. The next part, the girl children shall also be provided the stipend, honorarium, financial assistance, as may be admissible as per the policies framed by this, the NCT government from time to time. Next paragraph. The Delhi police will ensure that no harm is caused to the victim or the children, and they are adequately protected. Next paragraph. The as regard to the allegations contained in the FIR or otherwise, the scope may not be taken to have expressed any opinion on touching the merits thereof. The investigating agency will ensure that the investigation is conducted in a dispassionate, fair, and impartial manner, and an appropriate report will then submitted to the court of competent jurisdiction at the earliest. At the earliest. What else? Because we can't, we should not keep this proceeding pending for a long.
Yes, your lordship may dispose it. It's only one issue, your lordship, regarding the strengthening emergency of medical, which your lordship on the last date of occasion have asked for the report, why they have refused to admit her, your lordship. On that, your lordship, at page 2, your lordship, I have given I have asked couple of directions, your lordship.
So far as inquiry against the private hospitals, JPC / ZTV, पूरा नाम लिख देना.
They are at page 2.
The role of the will be examined in depth, and a separate report to this effect be submitted to the court of competent jurisdiction. The victim may thereafter seek appropriate remedy, if any, that may be available in accordance with law. that may be available in accordance with law. Next paragraph. With these directions, these incident proceedings are disposed of.
I'm deeply obliged, Your Lordship, for taking up this cause, and the victim had shows gratitude, Your Lordship. Deeply obliged, Your Lordship.
Please, my lords. There is an item. Just one thing. My lords referred it to mediation. Your lordships referred it, and rightly so, with great respect, to mediation. And we bona fide went to mediation. I believe your lordship has a report, which I believe would be a failure report. But that apart, the reason it is failed is that I have a one-page chart. During the mediation, the same Prasad, which we are fighting against in this court, his three companies down the line, gets his third company to arrange his purchase by paying out 250 crores of a company called YY. It is done by his company, Moschip. Please give the chart. Please. And this is not the way to take cover of a mediation under your lordship's order and do these antics.
What otherwise, what happened to mediation?
My lord, may I
Apparently, it's failed well because we had 15 hours, 5 sittings, and 5 drafts. My learned friend and your lordship said, just give me a minute, just see this chart. Your lordship is familiar with the top names, his son-in-law and daughter. All these, I quest my lord is familiar. Now, Mayuka is a subsidiary. Just give me a minute. Orange, the orange or brown one. Lordship, you got that? Below that, Moschip. Moschip is the one which purchases by paying out 250 crores a company called YY. Now, all that I'm saying is they are going to approve it tomorrow by a shareholders meeting. I'm making it clear I'll file a contempt.
We are taking a serious objection to it, Mr. Singhvi. I think this is absolutely not right because but this is not, you're just trying to prejudice the court simply because this transaction is not related at all.
If you do prejudicial acts, I will prejudice the court.
We are willing to face, but this is nothing to do with this.
Para 11. Read your lordship's order, para 11. Let me finish, otherwise we'll be speaking over each other. Number para 11 of my lord's order, last order, just read that. Your lordships, when they say running day-to-day expenses, doesn't mean investment like this. We all understand in the ordinary course of business, running day-to-day. If you are so sure, you should have come and asked the court. It's as simple as that. It takes 1 minute to ask the court if you are bona fide. In order to facilitate, Justice Chief Justice has it, para 11, Justice Bakshi has it, para 11 of the last order. This is it's a term of art your lordship uses, it's not a layman's term. In order to facilitate, and that was, we were opposing, your lordship heard them, they said we need it, so your lordship gave them the leeway. To facilitate the respondents to run their day-to-day business. The order of 1510 is modified, clarified to the extent that the respondents may operate their assets second time now in the normal course of business. However, the immovable asset shall not be. Now, if you pay out on an asset 250 crores, we don't know the antecedent of the seller. Is that a normal course of business, fellas? Can it be on the face of a normal course without even the leave of the Supreme Court? I can understand your lordship vets it and says, okay, go ahead. Did you approach the Supreme Court? Answer is no. Board has approved. I have come to know of it. Luckily, the matter was coming today. So, as shareholders approved tomorrow. So, either your lordship to prevent further complications, status quo as of today, including shareholder. I may be wrong. He may be right, but you can't.
No, this question. We have something to say on this because I think this is simply first of all, to say that I came to know about is completely wrong. This was a SEBI filed information. It's an acquisition where the SEBI was informed in the ordinary course of business. A particular entity is to be acquired. And
in the ordinary course of business, you will not
it's not the, I can make it very clear. Today, first of all, the impression which has been given is that is money has given and nothing is coming. Today, our operating entity, which is in line of the business which this entity is carrying out, after declaring to SEBI, is acquiring that asset is coming in the fold of this entity in question. That asset remains with this entity. Today, to give an impression saying that we are selling off an asset is wrong. Today, assuming for a minute this listed entity or unlisted entities, they are going to a normal course of merger acquisition which are to be carried out after the approval of the regulator. Today, to present a case to say, no, you can't carry out anything and today the security has been provided. It's not that we are siphoning off something and the asset which has been not known to anyone. This is through a regulator in the market which is being acquired.
He's not denying. It's an admission. Whatever our friend said is an admission.
Make a submission? Lord, may I urge a submission for you?
I know. Yes, he's very lucky.
I'm sorry, my lord. I'm sorry. May I just
My lord, I must say, in fairness to the mediator, Chief Justice Lalit, that he spent a lot of time. He, my lord, actually did something which is bordering on a miraculous. My lord, on the 24th of April, he got parties to agree. It is in the matter of drafting, my lord, that there has been some hiccups. I, my lord, think that the work done by the mediator is so extraordinary that, my lord, he brought parties together. And it was his persuasive and, my lord, an extremely transparent way he has conducted these proceedings. My lord, they've inured to the parties' benefit. Under, my lord, the overall settlement, my client, Dr. Singhvi's, my lord, my friend, Dr. Singhvi's client, has a lot to gain. So too, my lord, is my client, because it is, my lord, a complete settlement. If they, my lord, come so close to it on 24th of April, just because, my lord, on ironing out the creases in the documents, my lord, immediately everybody wanted some sort of report to be submitted. But, my lord, I personally think, having considered the way in which the learned mediator has discharged the trust placed by the court, I think, my lord, we should go back to him and spend, my lord, some time and make sure, my lord, that we come out with an agreement which will meet with your lordship's approval.
So
and
let
I'm
me-
very, if I may say so, Dr. Singhvi, I'm extremely confident, my lord, that given the approach of the mediator, we should be able to arrive there. My lord, I have seen the document of 24th of April, where, my lord, which records the meeting of the 24th of April, where, my lord, all essential heads have been agreed. It just needs to be worked out, my lord, and the mediator is the best person.
I will say something against myself. No, I will say something against myself straight away. I share Mr. Subramaniam, although I can't put it with such soft reasonableness as he's putting it. Optimism about the mediator. He's tried his best. I will, despite the instructions to the contrary, because of their conduct, agree to continue mediation. I'm saying against the instruction. Provided, Malad, this kind of games don't go on under your lordship's knows the order itself.
Both of you are fully aware. In fact, all of you are rather. All of you are aware that is going on.
I'm with Dr. Singh.
CP is going on. It will take another 8-9 days.
No problem.
Right. You have time to.
No problem.
Meanwhile, no harm in waiting up.
Just said Lalit should be given a chance, Malad, in case he can do it. But Malad, this must be status quo.
Smile, Malad.
Literally, they were there.
So the mediator being in the United States is ready even to
Absolutely, yes.
We will say like this, that though the tangible results out of the ongoing mediation proceedings are yet to be seen. However, like learned senior counsel for the parties, this court is also confident that that owing to the stature status and the hard work done by the learned mediator, the parties will be able to reach some amicable solution.
Great.
Consequently, the main case is ordered to be posted on so-and-so date. Meanwhile, you maintain just...
May I just first of all, this is a third party, completely is not. How they are linking is, they are saying that one of the family members is holding 4% shareholding or 2%. Today, this is, well, these are, with all humility, I'm submitting that they just want to block the transactions which are in ordinary course. This can be made subject to outcome. Can be made subject to outcome. Well, these are all SEBI approvals have been taken. This can be made subject to outcome of the final what has been there. But today it is not going to help us. These are transactions fructify with the great negotiations, large exercise and due diligence is being taken. These are not off the cuff. These are family related transactions.
These are public listed
companies which are there.
With over 3.5 lakh shareholders.
Public
Today,
shareholders.
my lords, to say SEBI listed, you will not acquire.
Mr. Singh, we have no doubt to even have any apprehension about what you are saying.
Please, Malad.
But when we say that please don't carry on any activity apart from normal course of business.
Yes.
Acquisition of a company is not a normal business. You would have taken out an petition before us, sought the leave and gone ahead. This is something which we don't.
I'll tell your lordships very honestly, we would have. And as your lordships think that we should have, But honestly, my lords, no one in this matter by these are distant transactions. Just because a family owns a percentage of its
Small shareholding in a 3 lakh.
Would in all probability allow you to go ahead.
Yes.
But why do you put the cart before the horse?
But our only difficulty is would this mean for every company?
Wherever the one person is holding a
Wherever
share,
any
it can happen today.
family member owns the share.
Today,
Come before,
let's say family member holds a share.
we also have a difficulty after all. We've secured the award, my lords, also to a substantial extent, to which your lordships were kind enough to agree to. But today, my lords, to say that nothing will happen.
63% shareholding is public.
Place on record the nature of the transaction and the benefit which is
coming to this entity.
Would accrue to the company.
May I also say it is equally important if they have a grievance to file an affidavit, what we deal with. These are oral observations.
Regarding the
color charts.
involving-
That's why I deal with it. That company is not even a party here today.
Involving Moschip
Technology. Which is not a party.
YY.
The entity which is not a party.
Status quo regarding Moschip's transaction with YY purchase.
Meanwhile, the status quo is
Status quo.
These on a piece of paper which has been given to the court.
Now.
Nobody knows. All on a statement.
It is not a party.
It's not. This is the. It's a share based on a one piece of paper.
These papers should be
SEBI listing.
One IA taking out the. Then thereafter we'll pass the order.
No, but then it's tomorrow.
Yes.
Well,
Unfortunately,
can you violate your lordship's order while your lordship is having
This is
mediation?
themselves
taking a
Let it be
Turn
status quo, file tomorrow.
This is in all fairness, may I request the
because of the
we
ninth
will
judge,
file.
we haven't had.
status quo now. Status quo
May I make a suggestion, Mala?
share swap, share swapping or the share transfer share from Maple Enterprises to
Is acquiring.
respect of.
May I just suggest
in respect of technology limited.
just
One
suggestion. One suggestion.
Only one suggestion. If the meeting can. Very well. Very well. Yes.
Try to resolve all these issues.
Yes, my lord, they need to be resolved. My lord, may I make one suggestion? That your lordships may make it subject to orders of the court. Please make it subject to orders.
No, but the problem is
you
that
have gazed, my lord, over the transaction.
if there's a
It
dissipation,
can always
of
be unwound.
Yes,
you have
it can't.
authority.
It's a listed company. It can't be. It can't be unbound like that.
I said it is being made subject to orders.
Substantially securing
Across the bar to hand over a chart. The public listed company is not here.
But you are also not denying that.
They're not denying at all.
It's a
We have just received.
it's a third party.
Any public listed company in
Then there
which
is
the
nothing
family
left.
has a shareholding, you will bring it to the
You are
court
able
and say
to
the
resolve in 10
transaction
days.
will go through.
If you are able to resolve in 10 days, so
Thing in the meantime at least take place will not be given effect to.
Oh, that's
Only that can happen, my lord. The meeting can take place, it will not be given effect.
not just maintain status quo for 10 days. We'll consider that.
Whereas the shareholders meeting is tomorrow, it will not be given effect to.
But the
Let it at least.
Deferred. The meeting may be deferred.
grateful, boss.
Item 43. Letter.
Would your lordships keep it, my lords? Give us a date, my lords, because.
Yes. This would 10 days, 15 days. I think 2 weeks are sufficient to try.
The only thing is we are now with the vacations, my lords, the date would be
Before
important. That's
that,
why.
we are taking before that.
Yes.
We'll take up.
This will give an impetus to the creasing, ironing out the creases.
Well, in the meantime, we'll move this application before the court. Seek permission on this.
No, no,
Yes.
yes.
We will do that. We'll do that.
Move that
Because-
application and explain the transaction, how unrelated it is.
We will.
25th May Monday.
Very well. Very well.
In item 43, we have circulated a letter. In item
This
43, we have circulated a letter, and interim orders to continue in that. Much of.
I'm given to understand.
Item 44.
I'm sorry, my lord. I'm given to understand.
Main case, I is for direction. Post this main
These
case.
are for conducting elections where there are no.
Item 45, there is a letter.
Very well.
Item 46.
Please, Lordships.
Oscar brother,
It's in 46 minutes. Milods, in the impugned judgment.
Item 44, your lordships are urgent. Item 44, your lordships are urgent.
We are listing on a date for hearing. Main case.
Milods, in 46, the impugned judgment in para 55 records that
What happened to mediation has failed?
mediation has
failed, Milord, I have a suggestion.
For arguments on
Milord, I have a suggestion, Milord.
This can be listed
The
for
matter
final
be referred for arbitration. The matter be referred for arbitration.
No, Malati, we have serious objections about it. We have a protection. They're sitting listed for final hearing. We'll argue it out.
What happens if I withdraw my SLP? What happens if I withdraw?
Withdraw whatever the consequences will follow. Then I don't ask the court's order.
No, if you want to withdraw, we'll be very happy to finish it.
What I'm saying is that the grievance of the other side is that Section 8 ought to have been allowed by the trial court. Against that order, Milords, the appeal was filed under 37.
We have not seen it yet. 2020.
But they listed any day final for hearing.
I'm only making a suggestion. It may be referred for arbitration.
No, we are objecting to it. The final.
Both sides are acceptable. It's all right. Otherwise, we have to adjudicate. Item 47.
Very well.
Please, Lord, we have finally the arbitral tribunal is in place. It has started to function. Arbitral tribunal is in place.
Now it is working.
Yes, three learned members have joined the tribunal. Dispose of only, my lord, the first arbitration we are reserving. Madras High Court has passed an order. We are reserving our right under 37. That's the only thing we are talking about. Otherwise, the tribunal is functioning.
Additional Solicitor of India representing the petitioner as well as non-senior counsel for the respondent state that the arbitral tribunal is now functional. The instant petition is accordingly disposed of as infectious or without prejudice to the right of the petitioner to challenge the order of the Madras High Court.
In section 37.
Which has been passed subsequently.
We know this earlier we have time, so we want to file 37. That liberty may be reserved. That's all.
Not correct.
Obligation.
Item 48.
48 is for appointment of the arbitrator, my lord. Last time there was nobody appearing from
I can take instructions as to whether we want to appoint the third person or Lordship, after the amendment, Lordship will see international arbitration, whether Lordship will refer it to any institution of Lordship's pleasure.
Lord, with greatest respect.
Either of them.
Lord, this is covered by core.
11.4, Lordship will have to, there is an amendment.
So in the arbitration notice
We'll take a look at, 11.4 now, subsequent to the amendment, means that it has to be referred to a institution. The court will then have to refer it to institution who will then proceed with that.
We'll see what institution, where is the institution.
Well, I am not, that's what the Act says. I was surprised that it does exist in that.
In any case, we will appoint an arbitrator. We will see what is the impact of section.
11.4. Malat, we'll just take a look at 11.4. I was surprised that there's that sort of an Malat. I was surprised because my experience was that it's always the court then goes on to appoint. But then there is an amendment in 2019 which then says that the court will have to, an institution. Malat, we'll look at 11.4. I'm just.
Where are the credible institutions?
Well, that's a separate issue, Malat, but that's the law. And I said whether it's been brought into effect, it has been brought into effect as well. So, I'm just submitting. I'm just submitting as it is. It's a three people arbitration.
Neutral.
Three of them. Either we can come back with a name and then they can choose a third person because they've nominated theirs. We have not nominated ours. There's a possible. If Lordship so pleases, we can come up.
You can nominate yours, then we'll.
And then the third person.
Appoint some common arbitrator. Not the value of the dispute.
There has to be 3. It's a panel of 3.
Not the contract says 3. But they never appointed their nominee, and Lord, I'm only requesting
only one single arbitrator.
Single arbitrator.
But if there is, then the provisions would apply. There are 3, then there would be 3 because the provisions are to that extent quite clear.
11.6 will override your contract if you are not working it out.
Yes.
According to us, 11.3 would therefore hold the field.
11.6 will override the terms of the contract if it is not worked out.
That's
Obligements. But Lordships have passed an order in 48.
Item 49 is also an international arbitration. I am for the petitioner seeking appointment of an arbitrator. What's my claim? There is a Swiss company, but they have not been appearing. I have already served them the office report notes I have served.
All right, we'll appoint someone.
I am so grateful.
Item 50, there is a letter.
There is an opposition to that, not with respect, because what they're doing is they're delaying them to section 11 and proceeding otherwise. Could be on a short date. In item 50,
लेटर दिया है अपॉइंटमेंट ऑफ आर्बिट्रेटर
Because not the agreement is clear.
My lords, may kindly have it on Friday or when?
Friday.
They're proceeding parallelly, but not wanting to.
Tonight, Friday.
Deep.
Objection.
Deep reply.
Your Lordship, item 49 was called out. This was 14.
Item 52.
Malot 51. Malot's an item 51, Malot's 51, 51.1, 51. Your Lordship. Plus, we're more than willing to have the matter settled, Malot's. Plus, may refer it to mediation, Malot's. 51, 51.1, 51.2. Oh, sorry.
51 item Friday.
Your Lordship, item 49, Your Lordship.
Now whatever 49.
Your Lordship, we want to file a reply. We are challenging the existence of the arbitration agreement.
That is right before the.
No, Your Lordship will just give us 2 weeks. According to our client, the arbitration agreement doesn't exist. The arbitration agreement is not with us.
Counter affidavit we filed subject to cost of 25,000. Next.
Please, 51 is on Friday.
Item 52.
Please, no. Look, this is petition seeking appointment of the arbitrator. It's an international commercial arbitration. They have duly admitted the arbitration agreement, Lord. In the reply to
my only objection being it is nowhere stated either in the agreement or in the application before your lordships as to where it is incorporated to call it an international commercial arbitration.
Very well.
Nowhere they said that it is in it. 2F requirement is that it should be incorporated in any place outside India. The only mention about having office, nowhere they said where they are incorporated.
Nowhere?
The petitioner was incorporated.
This is not an international.
In the cause title or in the agreement, I am an Indian entity.
Not, I am a foreign entity. I am incorporated under the laws of UAE. In fact, the main agreement also talks about that. They were duly aware of it.
No,
in fact, in my reply to the legal notice, they have admitted the arbitration clause. Not the agreement. Not the
agreement is same thing. How does it?
Thing is requirement. They should state at least to that extent. If it is registered in UAE or any other place.
Petition.
It places on record your incorporation. Or
very well. Very well, Manoj.
Post consul should do.
Obliging.
Item 53.
Well, this is again an international commercial arbitration, my lords. So the sole arbitrator has to be appointed. There's no dispute on the arbitration clause.
Who is there for the respondent?
Well, HOACL and my lords, they've been served as per the office report. R1 and R2 both are served, my lords. Geopetrol and HOACL.
Your report is awaited, sir.
Well,
on the local address, it is complete.
But as the project office is in Chennai, they've been served here. The main office. It's a 100% subsidiary of R1, my lords.
It seems that service, as per the office report, service on the local address is complete. However, notice sent on the address in Mauritius is still awaited. Post the so and so date to await for completion of service and or to enable the respondent to enter appearance. Just will give one chance and.
My lords. Deeply.
We are, my lords, at the fag end of the election process. Only one more Madhya Pradesh is left out. Election is tomorrow, my lord.
We would like to the NCT Delhi also to look into this kind of organizing when this violence has taken place. What have you done?
We will get it.
I'll
file a status report.
We'll do that, my lord.
And consult for the PCI seeks and granted 1 week time to file the status report.
We'll do that, my lord.
Pleasure.
Item 55.
Yes, my lord, this matter needs, my lord, lordship's consideration, my lord. What is happening, my lord? There are gangs.
Then we have no time, Mr. Upadhyay.
Just, my lord, I used to point out. I will take only 1 minute, my lord. One of the leading newspaper, my lord, had done a sting in the Lucknow, and there are rates. The false rape cases by the married women, cost is 10 lakh.
We will see on the next date.
False cases by 40 to 15-year girls. So it can also can be rate is the malad 20 lakhs.
Some date, give a date.
So malad any short date malad is very important. Malad innocent citizens are committing suicide malad.
Give a short date. Item 56.
Your Lordship. Your Lordships have issued limited notice on transfer of prosecution complaint from Gurgaon to Delhi. ECIR is in Gurgaon, but ED arrested the accused and under section 19(3) produced the accused, my lord, in Delhi, in Saket, Delhi. Bail is granted by the Saket court. The anticipatory bail granted by Saket court.
Where is the counter?
The counter has been filed by them, my lord.
Check for counter. There is no counter with us.
Huh?
No counter. From the counter has been filed.
You enter also.
I just need to check the same with the paper book. Post it on next Monday.
Please, my lord. Grateful.
Next Monday.
सारी दुनिया भर के मैटर एक दिन में इकट्ठे कर देते हैं.
Malads, this is that SIT report. Would your lordships would have seen it, Malads. It was
Investigation is complete.
investigation is complete, Malads. The SIT wants to now hand over to the local police so charge sheet can be filed, Malads. The SIT members are also logged in, Malads. All the 3 IPS officers. They have, Malads, managed to nab the actual culprit. And if your lordships will have the report, Malads, I have seen it. I've not given
We don't have a
copies to
copy
anyone
yet
else.
of the report, your lordship.
We've not
been
given
provided a
copies to
copy of the
anyone else.
report.
I'm the only one who has seen it from the state side also. I
It
interacted
could be
with
provided a copy, your lordship could have it after a week.
We will not entertain any objection here against the report. That has to be done before the court.
We understand that, your lordship, but if your lordship would kindly give a direction that this report be provided to us, and then we'll take our objections before the trial court.
Your lordships
No,
may.
court is bound to provide you copy.
Yes.
The court of competent jurisdiction will provide you, will direct the court to provide.
Grateful.
And there you
And
can always
including
file your
the
objection.
status report filed before your lordships, if that could be provided to us. It's including the status report filed before your lordships.
No,
Court.
we will not entertain objection. What are you doing? That is to be done before the court concerned. If at all you are, if you are happy, you are happy.
Fair enough, your lordship. We
Malads,
will know only when we see the report, your lordship. We haven't seen the report.
SIT. The copy of the report has not been given. I am actually the only one who has seen it because I thought I should see it to assist your lordships. But my lords, the SIT has managed.
Please proceed. Since the investigation is, the SIT has completed the investigation, let the investigation report be filed in court. It goes without saying that the court of competent jurisdiction will provide a copy of the investigation report to the victim's parents to enable them to assist the court in accordance with law. The court will provide a copy of the investigation report not only to the accused but also to the parents of the victim to enable them to assist the court in accordance with law.
My lords, the investigation report may be permitted to be filed through the jurisdictional SHO, my lords.
It is permitted to file before the jurisdictional court.
Through the jurisdictional SHO. Because SIT cannot file, my lords. It has to be the police station. Through the jurisdictional SHO.
Through the local police station.
Local SHO.
Before the court of competent jurisdiction.
That's fine.
As well through the jurisdictional police station before the court of competent jurisdiction.
I'm grateful, my lords. So we'll proceed to file charge sheet now, my lords.
Any other issue that?
Yes, I have one request. In fact, on 25th of March, your lordships had issued notice to the head of the pediatric unit of Max Hospital. I have given my statement to the police twice. They came after 47 days and then perhaps an impression was given to your lordships as if I've changed my statement. I filed a detailed affidavit, no statement was changed.
That I think we should examine the conduct of the government hospital doctors. They indulge in a lot of...
I am for the Max Hospital, Mulaj. It is on the basis of my report.
We would like to seek your assistance, Madam Asuriya. Post the matter for further consideration on so and so.
I'm grateful, my lords. Alas, the SIT members can be discharged. They are online.
The SIT members say we express our satisfaction and thanks to the members of the SIT who have done a commendable job by completing the investigation in time-bound manner. Regarding the complicity of negligence to complicity of the medical officers as well as the victim's compensation shall be determined on the next date of hearing.
Please,
It's a post-concern.
Grateful.
Most grateful, yeah.
Item 58.
59, 58, my lord, the report is almost ready. They have kept it on 29th for final meeting, my lord. May I have it after vacation, my lord?
All right.
Then we kindly be directed to supply the copy of this. Highly obliged.
Item 59.
Highly.
Say they have not filed any reply so far.
Some reports from the Central Provision Board has come counter affidavit. Have you received, Mr. Sharma? Have you got a copy of the counter affidavit by Central Pollution Control Board?
Last time they sought for which time, my lordship?
No, they have filed, but they give a copy. Who is for the Central Pollution Control Board?
I am for union.
So,
Only one party has filed the reply.
counter affidavit by respondent to Central Pollution Control Board has been filed, but it appears that copy thereof has not been known to the petitioning person. Let the registry provide a soft copy, or let the counsel for the CB or the registry should provide a soft copy to the petitioner.
My lordship, was some mistake. I should also be given time.
You may file if your rejoinder reference will file within 4 weeks up to the date of after getting the copy. Post the matter on so date. Yes, item 60.
No, thank you. Good.
Covered by home.
Lord, it is covered back.
Compensation matter.
Lord,
Covered by.
Yes, my lord. Interest for the delay period should not be recorded.
Allowed, but no interest for the delay.
most.
Just mention.
So that may I mention item 59, I'm very sorry. I'm for respondent 8, the name has been wrongly recorded. And so they're not taking my wakalatnama. The Lordship may just record my submission, which is right for respondent 8. Item 59.
Senior counsel pointed out that the name of respondent 8 has been wrongly described in the memo parties. He is permitted to file a corrected memo parties as well as wakalatnama on behalf of respondent 8.
I'm sorry.
Number 8.